beginnen. Herzlich willkommen zu dieser Veranstaltung. Mein Name ist Philipp Anzenberger. Ich bin assoziierter Professor am Institut für Zivilverfahrensrecht und Insolvenzrecht der Karl-Franzens-Universität Graz. Und ich habe die große Ehre, aus österreichischer Sicht ein EU-Projekt leiten zu dürfen, nämlich das Projekt Train to Enforce. Konkret handelt es sich hierbei um zwei Schwesterprojekte. Ein Projekt unter der Leitung von Professor Nona Krautgasser, das EN4CE, ist ein eher wissenschaftliches Projekt, das sich mit grenzüberschreitenden Forderungsvollstreckung im europäischen Rechtsraum, also insbesondere der EuGVVO, beschäftigt. Und dieses Projekt namens Train to Enforce ist ein Projekt, das sich eher an die Praxis richtet, in dessen Rahmen Schulungen für Richterinnen, Rechtsanwältinnen und Notarinnen durchgeführt werden in Bezug auf die Europäische Mahnverordnung und die Europäische Bagatellverordnung, weil die aus Sicht der Europäischen Kommission noch nicht so im Rechtsleben verankert sind, wie sie das gerne hätten, obwohl das ja eigentlich sehr potente Instrumente zur grenzüberschreitenden Forderungsbetreibung sind. Lassen Sie mich ganz kurz mich bedanken, zunächst bei meinen Mitarbeiterinnen, insbesondere Frau Magister Wolkersdorfer, die wirklich unschätzbare Arbeit bei der Organisation dieser Veranstaltung und auch anderer Veranstaltungen im Rahmen dieses Projekts geleistet hat. Vielen Dank. Auch bei der Institutsleitung meines Instituts, Frau Professor Nona Krautgasser, die hervorragende formelle Rahmenbedingungen geschaffen hat, damit das alles reibungslos funktioniert. Ja, meine sehr verehrten Damen und Herren, was passiert hier jetzt eigentlich heute? Im Rahmen dieses Projekts, wir haben ja da verschiedene Partneruniversitäten aus verschiedenen Mitgliedstaaten. Neben Österreich sind auch Deutschland beteiligt, Slowenien, Kroatien, Spanien, Italien, Schweden und als Beitrittskandidat Albanien. Und unsere ersten Schulungen haben ja schon stattgefunden. Das ist heute der dritte und letzte Termin im Rahmen dieser Reihe. Und die ersten Schulungen haben quasi, wenn Sie so wollen, auf nationaler Ebene stattgefunden. Das heißt, von ÖsterreicherInnen für ÖsterreicherInnen. Wir hatten tatsächlich auch Gäste aus dem Ausland, aber im Wesentlichen war es so geplant und konzipiert. Und diese dritte Einheit, die findet jetzt grenzüberschreitend statt. Jetzt hat uns der Corona ein bisschen einen Strich durch die Rechnung gemacht. Also an sich wäre vorgesehen gewesen, dass tatsächlich die Vortragenden bei uns da sind und sie auch persönlich kennenlernen können. Aber immerhin, jetzt funktioniert es halt über Zoom, ist auch nicht das Allerschlimmste. Ja, und wir haben also heute, also ich und die Frau Magister Wolkersdorfer und die Frau Magister Arneitz und die Frau Dr. Schkoff, wir waren schon in Kroatien, haben dort schon eine Schulung abgehalten und jetzt heute haben wir Kolleginnen aus Kroatien hier bei uns im Webinar, die sowohl von Universitätsseite als auch von der Praxisseite uns etwas erzählen werden zur Europäischen Mahnverordnung und zur Europäischen Bagatellverordnung. Ich darf die Referentinnen ganz kurz vorstellen. Wir haben Professor Ivana Kunda. Sie ist Professorin für internationales und europäisches Privatrecht an der Fakultät von Rijeka. Sie ist außerdem Forschungsdekanin an dieser Fakultät und also beschäftigt sich insbesondere mit europäischen und internationalem Zivil- und Zivilverfahrensrecht, außerdem mit Immaterialgüterrecht und internationalem Wirtschaftsrecht. Wir haben meine liebe Kollegin Daniela Wrobuljanak. Sie ist Assistenzprofessorin an der Universität Rijeka und auch sie beschäftigt sich mit europäischem und internationalem Zivil- und Zivilverfahrensrecht und allem, was also Internetrecht und Informatikrecht betrifft. Außerdem eine junge Kollegin der Universität, Martina Ticic, die ist Universitätsassistentin in Rijeka und schreibt gerade ihre Doktorarbeit. Und wir haben zwei Damen aus der Praxis. Ivana Manestar, sie ist am Commercial Court in Zagreb, also am Handelsgericht in Zagreb tätig, und Srinka Tironi am Municipal Court in Split, also am Bezirksgericht. Hello. Good to meet you. I'm just presenting you in German. I hope that's okay for you. Bezirksgericht in Split tätig und die beiden Damen werden uns Praxiseinblicke bieten. Und damit, so basically, I'm going to switch to English now. So I'm passing the word to my dear colleague Daniela now. She will also say some words as an introduction from our Croatian partner side. And then we'll give the word to Ivana Manestar and she will have the first presentation. Thank you so much for being with us, for having those presentations. We're very excited. And well, the word goes to you, Daniela.
Thank you, Philip, and thank you for presenting us. Thank you for presenting the project. I do not speak German, but I'm pretty sure you introduced all the partners. That much I got. Hello to everyone, and thank you for joining us in this seminar. As Philip announced, I'm Daniela Verbianac, the assistant professor at the Faculty of Law in Rijeka, and I'm a part of the project Train to Enforce. So this seminar on European Order for Payment and Small Claims Procedure is organized within the Train to Enforce project, which is actually a project coordinated by the University of Maribor, both University of Graz and University of Rijeka Faculty of Law are project partners, and we are co-organizing this seminar. So I would like to just briefly tell you a few words about the project. It started in 2019 on 1st October, and it lasts in total for 30 months. So it will end next year in 2022. And apart from our two universities and the University of Maribor, there are there are universities from 5 more countries, 4 member states and 1 candidate country, as you already heard from Philip. And the aim of this project is to create draft materials on European order for payment procedure and small claims procedure, and to conduct free multilingual seminars and workshops such as this one on these sources of European private international law for cross-border collection of claims. And why is the project focused on these 2 regulations is I'm sure you are already familiar with. These regulations were introduced within the package, which was supposed to supplement Brussels 1 bis regulation, which is the regulation containing rules on international jurisdiction and rules on enforcement and recognition and enforcement of foreign judgments. The project is aimed at these 2 regulations. However, it does not deal with the 3rd regulation enacted within this package, which is the regulation on uncontested claims. And why is this the case? Since the Brussels 1 bis regulation abolished the exequatur procedure and the recognition and enforcement became simplified, it doesn't make much sense to deal in detail with the regulation on uncontested claims. Since this was the regulation enacted, it is actually the oldest regulation enacted within this package, which dates back to 2004. And what this regulation introduced is a parallel simplified procedure to the one already existing under Brussels 1. And it actually abolished exequatur procedure for certain categories of judgments. But since Brussels 1 bis, the regulation from 2012, abolished exequatur for all judgments in civil and commercial matters, we can say that regulation on uncontested claims doesn't bear much importance, or at least compared to the importance it had when it was introduced. So basically, small claims procedure regulation and European order for payment regulation, they introduced European civil proceedings. And as you will hear during these 2 days, these regulations are aimed at simplifying collection of debt cross-border. European order for payment procedure is aimed at collecting pecuniary claims. However, if it is likely that the defendant will challenge the judgment, then the other regulation is advised to be used, the small claims procedure. And I think I can mention the activities that we have done so far within this project. I'm not sure whether some of you already participated in national seminars organized by University of Graz. There were two seminars, one on European order for payment and the other on European small claims procedure, and the same was done in Croatia. And this is the third and I think the final seminar within this project, which combines these two topics. And the aim is creating these free materials, which will be available online for self-training, and based on the materials developed for these seminars, a handbook on European order for payment and European small claims procedure will be published. So I don't want to take more time, and I would like to give the floor to Judge Ivana Manesta. Thank you.
Thank you, Daniela. Good afternoon, everyone. I will try to present you with some basic information regarding the application of this EOP regulation, some information regarding the actions that are expected to be done on the side of the plaintiff, the court, and the defendant. What are the terms of enforceability of this EOP? And I will quickly go through with some relevant CEU practice regarding the application of this regulation. So let me just point out. Okay.
That's perfect. We can see it.
You can see it? Okay, fine. So what is the European Order for Payment? So it's one of the EU instruments of cross-border collection of pecuniary claims in civil and commercial matters. So for claims up to 5,000 euros, its rival is, of course, European Small Claims Procedure, but EOP is significantly more used in practice than ESCP because it is much more faster and more efficient. This regulation is applicable from December 2008 in all EU member states except Denmark, and it was amended by the regulation which was adopted in 2015. The application of this regulation entails mainly the usage of standard forms from A to G that are set out in the regulations annexes, and in a smaller extent when it comes to situations which are not regulated by this regulation by adopting procedural decision pursuant in Croatia Civil Procedure Act. So it is recommended that all these standard forms, which are set out in the regulations annexes, are filled out online. So the participants can find interactive forms on this website in German language. So I mentioned earlier the term civil and commercial matter. This is a term that is always interpreted pursuant to relevant EU law by the CEU. So matters that will fall outside of the scope of EU regulation will be, of course, revenue, customs, and administrative matters, or the liability of the states for the acts and omissions in the exercise of state authority, rising property arising out of matrimonial relationship, wills and succession, bankruptcy, liquidation, compositions, and other analogous proceedings, social security, and claims arising from non-contractual obligations, unless they can be subject to an agreement between the parties, or there has been admission of debt, or they relate to liquidated debts arising from joint ownership of property. So the basic thing to find out, of course, is which national court will have jurisdiction for the issuance and later the review of EOP. And this will be determined in accordance with the relevant rules of Regulation Brussels 1A, except when it comes to claims arising from consumer contract and the defendant is a consumer, then only the courts in the member state in which the consumer is domiciled shall have jurisdiction. Domicile is once again determined, of course, pursuant to the articles of Regulation Brussels 1A. So whether a person is domiciled in a particular state is determined pursuant to the laws of that exact state. In Croatia, until 1st September 2019, my Commercial Court of Zagreb was the only court that had jurisdiction to issue and review EOPs. But since then, all first instance courts have been given jurisdiction, depending on the subject matter. So in general, commercial courts in Croatia have subject matter in all of the disputes that have arisen between legal persons and tradesmen. Croatian first instance courts will examine their territorial jurisdiction pursuant to the provisions of the Regulation Brussels 1A, because the national provision that regulates territorial jurisdiction is not in accordance with that regulation, and because the said regulation determines not only national jurisdiction, but territorial jurisdiction as well. For example, in matters relating to a contract, there is a special jurisdiction of the courts for the place of the performance of the obligation in question. So what is the basic action that is expected from the plaintiff? Of course, to make an application for the issuance of EOP by using a standard Form A. So regulation contains provisions regarding mandatory and optional content of this application. Mandatory content would be to name the names and the addresses of the parties and their representatives, and the court seized, to state the grounds for jurisdiction, to state what is the cross-border nature of the case. So is at least one of the parties domiciled in a member state other than the member state of the court seized? What is the amount of the claim? What is the interest rate if interests were demanded? What is the cause of the action? Description of the evidence, not the delivery, only the description, and of course the signature of the plaintiff or his representative.
Excuse me, Ivana, I'm sorry I interrupt you. I just wanted to tell you that if you changed your slides, we're still at the first slide. So in case you already are at the second
slide,
I can see the first slide. I'm not sure if that's the same for other participants.
I changed it to...
Yes, I can also see the first slide.
Only the first slide, because I changed it to the fourth slide, and I don't know what's exactly happening.
So we could try. If you are you in presentation mode now, we see the.
Now you're on the fifth slide.
Yeah.
Okay.
So I will present it like this because I don't know what happens when it's okay. Is it okay now?
Sure, that's perfect.
Okay.
Thank you. Sorry for interrupting you, but I thought that's
good for you that you told me. So I was speaking about the mandatory and the optional content of this application for the issuance of EOP. I stated that the mandatory content relates to names and addresses of the parties and their representatives, and the court seized, then grounds for jurisdiction, cross-border nature of the case, amount of the claim, interest rate, description of evidence, only their description, not their delivery, and of course the signature of the plaintiff or his representative. Optional content, but the plaintiff can always give additional statements explaining the claim and the interest. And you have Appendix 1 and 2 of this application. In Appendix 1, you can give some information regarding the payment of course fees. And in Appendix 2, the plaintiff expresses his will regarding the procedure which will take place in the event that the defendant submits a complaint against the EOP. So does he want the procedure to terminate or to continue pursuant to the rules for European small claims procedure, if applicable, or pursuant to the ordinary civil procedure of the court of the state of the origin. Application is submitted via means of communication accepted by the member state of the EOP's origin. So on this website, e-Justice Europa EU, Croatia published that forms, other applications and statements are to be submitted in written form by fax or email. However, after that information was published, there was a change in Croatian Procedure Act, which stated that all lawyers, liquidators, expert witnesses, so on, and legal persons are obliged, when it's technically possible, to communicate with the courts electronically via e-communication information system, which entails, after the prescribed registration is done, using a special electronic mailbox, an electronic signature, and the presumption that the addressee has been served if he didn't open the mail within the 15 days of delivery. However, with persons domiciled outside of Croatia, we do not insist on electronic communication. Why? Because this information regarding obligatory use of electronic communication is not published nowhere. So insisting on this electronic communication would complicate and slow down cross-border collection of pecuniary claims, which would be contrary to the proclaimed purpose of the EOP regulation. Besides, service of judicial documents is regulated by the provisions of the EOP regulation, and this regulation on service of legal documents from 2007, and those provisions do not allow us to impose electronic service attested by an automatic confirmation of delivery to person domiciled outside of Croatia. So regulation of service of documents from 2007 contains no provisions regarding electronic service, and EOP regulation states that the service is made in accordance with the national law of the member state in which the service is being executed, bearing in mind that the defendant has to in advance explicitly agree to electronic service attested by an automatic confirmation. Although new regulation on service of documents came to force in December 2020, it is not applicable until 1st of July of 2022. This regulation introduces a decentralized IT system as means of communication between the transmitting agencies and receiving agencies, finally an assistance to the courts in addressing inquiries, and an electronic service. But main condition is again prior express consent of the addressee to the use of these electronic means for serving documents in the course of legal proceedings. What are the main actions of the court? The court, of course, after receiving the application for the issuance of FIOP, has to examine it. What does he examine? He examines whether the claim falls within the subject matter of FIOP regulation. Is there a cross-border element? Is the claim monetary? Does it contain a specific amount? And is it due at the time of the application? Has the court jurisdiction the subject matter? Does the form contain mandatory data? And whether the claim appears to be prima facie founded. So according to relevant CEU practice, this list of requirements set out in Article C of FIOP regulation is not minimal but exhaustive, meaning that national court cannot ask from the plaintiff to meet some other additional requirements or to deliver some other additional information. However, in a latter case, he stated that although the list of mandatory requirements is exhaustive, that does not exclude an obligation of the court to request from the creditor additional information relating to the terms of the consumer agreement supporting the claim at issue in order to carry out an ex officio review of the possible unfairness of those terms. If the requirements set out in Article 7 are not met, so if the application does not contain all the mandatory data, and unless the claim is clearly unfounded or the application is inadmissible, the court shall give the claimant the opportunity to complete or rectify the application within a specific time limit using the standard form B. So, for example, when the application is not filled out in our court standard void Croatian language, or there was a suspicion that there was no jurisdiction of Croatian courts, or there was a jurisdiction of Croatian courts, however, there was no subject matter jurisdiction of a commercial court, and it was not clear which of the municipal courts had territorial jurisdiction, or the plaintiff was represented by a lawyer without the power of attorney, or the amount of the claim was not clear, the time during which the interest was supposed to accrue was not specified, etc. If the application is only partially founded, which means the application contains all the necessary data and is prima facie founded, then the court invites the claimant, using the standard form C, to accept or refuse the court's proposal of issuing FIOP only regarding that certain amount of the claim, warning him at that time that if he refuses the proposal, the application for the issuance of FIOP shall be rejected in its entirety. So if the claimant accepts the court's proposal, FIOP shall be issued only for that part of the claim accepted by the claimant. And regarding the remaining part of the initial claim, the court in Croatia does not formally adopt any decision, since it is considered that the claimant withdrew the application regarding that part of the initial claim, and any decision confirming that withdrawal would be of only declaratory nature. So there was a case when the demanded interest rate was too high pursuant to the applicable material law, or where there was no court jurisdiction for all of the claims, but there was for some of them. For example, if the claim arose from a sale purchase agreement and the defendant was not domiciled in Croatia and the merchandise wasn't delivered in Croatia, but in some other state, then there was no general or special jurisdiction of Croatian courts. And regarding that part of the claim, it was unfounded. So the court will reject the application using the standard form D in these numbered cases. So if the claim does not fall within the subject matter of FIOP regulation, if there is no cross-border element, if there is no monetary claim of a specific amount, which is due at the moment of the application, if there is no jurisdiction of the court, if the claim is clearly unfounded, if the claimant failed to complete or rectify the application within the time limit specified by the court, or the claimant failed to answer the court's proposal for the modification of the application, or he has refused the proposal. There is no right of appeal against the rejection of application. However, there is also no res judicata, so the claimant can submit a new application for the issuance of FIOP or use some other procedure for the collection of his pecuniary claim. So in my court's practice, we had all the grounds for rejection application stated here above. When we had no jurisdiction, neither general or special, is when the defendant was not domiciled in Croatia, the delivery of goods for which the claimant was seeking payment has not been made in Croatia, which was clear from the submitted invoices, or the services weren't provided in Croatia, or when the claim arose from an agreement for the provision of legal services to a consumer, and the consumer was not domiciled in Croatia, so only the courts of the member state in the territory of which the defendant is domiciled had jurisdiction. But if the claimant wanted to collect his claim through a regular civil procedure, the lawsuit could be, under some conditions, submitted even in front of the court for the place of the provisions of legal services pursuant to Article 17.1 of Regulation Brussels 1A. So we had a case when the claim was arising from an obligation of real estate property co-owners to contribute to the cost of maintaining the communal areas of that property in proportion to their ownership share, which is in Croatia an obligation prescribed by law. So our court deemed that this was a legal non-contractual claim, which falls within the scope of EU regulation as an exception set out in Article 2.2d. But since the defendant was not domiciled in Croatia, but in another state, and there was no basis for special jurisdiction of Croatian courts, we rejected the application on the basis of lack of jurisdiction. However, Court of the European Union did not agree with our standing point. He concluded that a conclusion of a contract is not a condition for the application of rules on special jurisdiction set out in Article 7.1 of Regulations Brussels 1A. However, that there has to be an obligation freely assumed by one party towards another. Monetary obligations, which are based in relationship between an association and its members, are considered matters relating to a contract. Even if the membership of an association of property owners is prescribed by law, the fact remains that the detailed arrangements for management of the communal areas of the building are governed by a contract, and the association is joined through voluntary acquisition of an apartment together with ownership shares of the communal areas of the property. So that an obligation of the co-owners towards the association of owners must be regarded as a legal obligation freely consented to, regardless of the fact that the property owners in question were not involved in adopting that decision or have opposed it. So it was the conclusion of the CEU, Court of the European Union, that this is a matter relating to a contract for the provision of services of real estate management and maintenance, since by becoming and remaining the owner of a property in a building, each owner agrees to be subject to all the provisions in the act governing the association of property owners concerned and the decisions adopted by the general meeting of the owners of property in that building. So there was a special jurisdiction of the court for the place of the provision of services in question. In our case, special jurisdiction of our court, but we deemed it differently at that time. The other reason for rejecting the application for the issuance of PIOP is, of course, when the claim is evidently unfounded. So there was a case where the claimant was a buyer who fulfilled his obligation for payment in full, but did not in return received all of the goods. So he was demanding a reimbursement of payment in the proportion of the value of the undelivered goods. However, according to Croatian applicable law, he needed to rescind the contract priorly. And since he did not state that he has done that, he had no right to ask for reimbursement of payment, but only for a delivery of the remaining goods. The other reason for rejecting the application for the issuance of PIOP is when the application is not rectified within the time limit specified by the court, usually when it's not filled out, in our case, Croatian language. And of course, the application will be rejected when the claim falls outside of the subject matter of PIOP regulation. It was our court standing point that when the claimant already has an enforceable document which allows him to collect the claim, that he cannot seek legal protection under this EOP regulation. So if he already has an enforceable court decision, then if this decision is a result of a public hearing during which the claim was disputed, but in the end accepted by the court, the decision is enforced pursuant to Regulations Brussels 1A. However, if the decision concerns an undisputed claim, for example, judgment by default, then this decision can also be enforced pursuant to this regulation, European Order for Enforcement of Undisputed Claims. And the same legal capacity in Croatia has an enforceable notarial deed, which is directly enforceable pursuant to this Article 2C and 58 to 60 of Regulation Brussels 1A, which is enforced on the basis of a certificate issued by the competent authority. The claim also falls outside of the scope of PIOP regulation if it does not concern a civil or a commercial matter, of course. So revenue, customs, or administrative matters and the liability of the state for acts and omissions in the exercise of state authority are not civil and commercial matters, and if in doubt, the interpretation in every single case is given by CEU. So these are the numbers of some cases where CEU mentioned or was deciding what is and what is not a civil or a commercial matter. So if all the requirements set out in Article 8 have been met, then the court will issue European order for payment using the standard Form E, generally within the 30 days of the moment the application was submitted, not counting the time taken by the claimant for completion, rectification, or modification of the application. Together with this Form E, the defendant will be served with a copy of Form A, the application, without Appendixes 1 and 2. EOP informs the defendant that he can pay the amount indicated in the order or oppose the order by lodging with the court of origin a statement of opposition using the standard Form F, delivered to him along with the EOP and a Form A within the 30 days of service of the order. If the defendant lodges a statement of opposition, then the procedure shall continue in front of the competent court of the state of the origin, pursuant to regulation on European small claims procedure, if applicable, or pursuant to rules of ordinary civil procedure, unless the claimant has previously demanded for the procedure to be terminated in such a case. This information will not be known to the defendant since it is contained in Appendix 2 of the application, which is not delivered to the defendant. Service of EOP is done in accordance with the national law of the state in which the service is to be affected, under the condition that it meets the requirements set out in Articles 13 to 15 of EOP regulation, bearing in mind that Regulation on Service Documents 2007 still applies, which will be replaced, as mentioned, by the regulation adopted in 2020. This means that if the delivery is to be executed in Croatia, then it will be done pursuant to relevant articles of Croatian Civil Procedure Act governing official service, since these articles meet the minimal conditions set out in Articles 13 to 15 of the EOP regulation. But if the Croatian courts need service to be executed in another member state, then the Croatian court will act in accordance with the Regulation on Service Documents 2007. And if we choose to execute the service via a receiving agency in the state of the execution of service, then that agency will be responsible that the national law it applies on the service of judicial documents meets these minimal conditions set out in Article 13 to 15 of the EOP regulation. In the past, there were practical problems when the exact address of the defendant was unknown because there were no legal instruments the courts could use in order to find out the address of a foreign citizen in civil and commercial matters. But this is going to change with the application of the Regulation on Service Documents from 2020. So the defendant has two legal remedies at his disposal: a statement of opposition and a right to review EOP in exceptional cases. Statement of opposition is lodged within the 30 days of the service of EOP, generally using standard Form F, which is served to him along with the EOP and Form A. Form F does not contain any reasons for disputing the claim, only an explicit statement that the claim is being disputed and the signature of the defendant or his representative. If statement of opposition is lodged timely, it prevents the enforceability of EOP, and the procedure shall continue in front of the competent court of the state of the origin, pursuant to regulation on European small claims procedure or pursuant to the rules of ordinary civil procedure, unless the claimant has previously demanded for the procedure to be terminated in such a case. According to relevant CEU practice, lodging a statement of opposition that does not contain any challenge to the jurisdiction of the court of the member state of origin cannot be regarded as constituting the entering of an appearance within the meaning of Article 24 of Regulations Brussels 1, which regulates implicit prorogation. And the fact that the defendant has, in the statement of opposition, put forward arguments relating to the substance of the case is irrelevant in that regard. So the defendant is not obliged to contest court's jurisdiction in the statement of opposition. He can do it later, but certainly before entering of an appearance in ordinary civil procedure. In the same way, the Croatian courts interpret lodging a statement of opposition against enforcement orders issued on the basis of documents such as invoices, bills of exchange, etc. After the prescribed time limit for lodging the statement of opposition has expired, the defendant has the right to apply for review of EOP in front of the competent court of the state of the origin in the following cases. So if EOP was served to the defendant by one of the methods prescribed in Article 14 of EOP regulation, this is the service without proof of receipt by the defendant, and service was not effected in sufficient time to enable him to arrange for his defense without any fault on his part. For example, a member of the defendant's household or his employee who received EOP on behalf of the defendant has delivered it to the defendant after the expiration of the time limit for lodging of statement of opposition. In other cases, when the defendant was prevented from objecting to the claim by reason of force majeure or due to other extraordinary circumstances without any fault on his part, or if EOP was clearly wrongly issued with regard to the requirements laid down in EOP regulation or due to other exceptional circumstances. So we have some explanation in the preamble of EOP regulation regarding the usage of this extraordinary legal remedy that states that review in exceptional cases should not mean that the defendant is given a second opportunity to oppose the claim. The claim should not be evaluated beyond the grounds resulting from the exceptional circumstances invoked by the defendant, and the other exceptional circumstances could include a situation where EOP was based on false information provided in the application form A. If the court rejects the defendant's application for EOP, the EOP remains in force, otherwise he becomes null and void. So pursuant to Croatian Civil Procedure Act, there is no right of appeal against the court's decision on the application for review of EOP, neither is restitutio in integrum allowed, since the remedy for failure to lodge a statement of opposition within the prescribed time limit is the application for review of EOP. So according to relevant CEU practice, the failure to lodge a statement of opposition to European order for payment within the prescribed time limit due to an error in calculation of that time limit does not constitute extraordinary circumstances within the meaning of Article 20 of EOP regulation, since it is a result of negligence of the defendant's representative, which could have been easily avoided, allowing for the review of EOP in that circumstances would mean that the defendant is given a second opportunity to oppose the claim, and that was not the purpose of this remedy. In another case, EOP was served to the defendants to the address from which they have already moved away from prior to that. And since they gained knowledge of the existence of EOP for the first time during its enforcement, the defendants made an application for review of EOP. But the court pointed out that in these circumstances, their service has not been executed pursuant to minimum standards laid down in Article 13 to 15 of EOP regulation, meaning that the time limit for lodging of statement of opposition has not even begun to run. Whereas the declaration of enforceability is invalid, so there was no basis for the application of review of EOP. In another case, EOP was served to the right address. However, the application form A, which was delivered in the attachment, was not translated to the language that the defendant understands. And in addition, the defendant was not informed by using this form from Annex 2 of the Regulation on Service Document 2007, that in that case, he can refuse to accept the document in question. So the defendant argued that due to the described irregularity, he did not understand the legal act which started the EOP procedure against him, and for him it was an extraordinary circumstances in the meaning of Article 22 of EOP regulation, which is basis for the application of review of EOP after its enforceability. However, the court considered that in that case, the service was not duly executed because every document which is being served of the defendant, regardless if it is only an attachment to EOP, needs to be translated into language that the defendant understands, and the defendant needs to be informed that if that was not the case, that he can refuse to accept that document. So, because the service was not duly executed, the court considered that the procedure must be regularized in accordance with the provisions of Regulation on the Service Document 2007 by communicating to the addressee the standard form in Annex 2 of that regulation, and only after that moment can a time limit for lodging the statement of opposition start to run. Therefore, the court concluded that EOP has not become enforceable, so there were no basis for the application of review of EOP. And in the last case, in the application for the review of EOP, the defendant stated that the court of the state of the origin of EOP was not competent to issue it because the parties in question have concluded a jurisdiction agreement according to which jurisdiction was given to the courts of the state in which he was domiciled. And given the fact that the claimant did not inform the court which issued EOP on the existence of that jurisdiction agreement in the application, the defendant considered that EOP was issued on the basis of false information. Whereas that EOP was clearly wrongly issued with regard to the requirements laid down in EOP regulation on jurisdiction. However, the court considered that the defendant knew the claimant has omitted the existence of a jurisdiction agreement in the moment that he was served with EOP. So he was able and obliged to lodge a statement of opposition for the same reason, since he has done not, and since he hasn't done so, he cannot be allowed to lodge for that same reason an application for review of EOP, because it would mean that he was given a second opportunity to oppose the claim, which was not the purpose of this institute. So the final conclusion was that in these circumstances, it was considered that EOP was not clearly wrongly issued with regards to requirements laid down in EOP regulation. In our court's practice, there have been a few applications for the review of EOP, always for the reason of not receiving it and becoming informed of its existence for the first time during enforcement procedure. However, the defendant must make these allegations probable, and if they are in contradiction to the documents in the file and they are not in any way sustained, then the court cannot accept the application for the review of EOP. For example, there was one case when the service was executed via a receiving agency in the state of the defendant's domicile by the delivery to a certain male employee of the defendant. And the defendant later on claimed that he has not actually received EOP because it was probably intercepted by his ex-wife, with whom he was at the time involved in a divorce litigation and so on, which allegations were not in any way sustained, of course. So he did not make these allegations probable, and there were no grounds for the acceptance of this application. If the defendant does not lodge a statement of opposition within the 30 days of service, EOP becomes enforceable. Declaration of enforceability is issued using the standard Form G, which is sent to the claimant along with another copy of EOP. EOP, which has become enforceable in the member state of origin, is recognized and enforced in other member states without the need of declaration of enforceability and without any possibility of opposing its recognition. Enforcement is governed by the law of the member state of enforcement. So the claimant needs to submit forms A, E, and G and their translation to the official language of the state of the enforcement. There are a couple of cases when the member state of enforcement can refuse to enforce EOP, and that is when EOP is irreconcilable with an earlier decision or order previously given in any member state or third country, provided that the earlier decision or order involved the same cause of action between the same parties, and that they fulfill these conditions necessary for their recognition in the member state of enforcement, and that the irreconcilability could not have been raised as an objection in the court proceedings in the member state of origin. And of course, the second case is when the defendant has paid the amount awarded in EOP to the claimant, but under no circumstances can EOP be reviewed as to its substance in the member state of enforcement. If the defendant has applied for a review of EOP, the court of the state of enforcement may limit enforcement proceedings to protective measures or make enforcement conditional on the provision of certain security, or under exceptional circumstances, stay the enforcement proceedings. In Croatia, the subject matter jurisdiction for enforcement, refusal of enforcement, stay, limitation of enforcement of EOPs is given to municipal court, whose territorial jurisdiction is determined pursuant to Croatian Enforcement Act. So this would be all. I hope I was clear, that didn't speak too quickly. If anything was unclear, you have any need for any clarification, please do not hesitate to ask any questions or forever be silent.
Well, thank you very much, Ivana, for this very concise presentation about the theory and case law on the European payment order, and also your practical insights. So we do actually have a question. May we see the page 2 until 4 of the presentation, please? I guess that is a possibility, but we can also send out the presentation to you. I think Ivana will not mind. Maybe I'm not sure. Did you screenshot the presentation, or is that what you want? Why you want to see it? And maybe if you go, just.
This is page 2. Do you see it? Page 3 and page 4. But you will email them the presentation, right?
So, Mr. Tischler, was that helpful for you, or would you like to have okay. Would you like us to send the presentation to you? That's fine. Okay, cool. Ladies and gentlemen, are there any questions to a Croatian judge? There's not so many opportunities to ask, I guess. So take the opportunity if you like. If
Of course.
Okay, sure, we can definitely do that. Eva, would you be so kind as to send out the presentations to the participants, please?
Of course, yes.
Thank you so much.
I don't know, do the participants have any experience with EOBs? Did they apply for the issuance of EOBs maybe in Croatia or I don't know, in Austria? And what is their experience?
So I believe some of the participants do, and others are also like we have some members of the university. I suppose they do not have that much experience with the EOP. Yeah. So please don't be disappointed. I was actually assuming that like people are a little shy, maybe because of the English language. Thank you so much for your presentation. And I already have seen Ivana Kunda this time.
Hello.
Hello, Ivana. How are you doing?
Oh, very well, thank you. I'm glad to be joining you.
Yes, we're glad as well. Okay, so thank you for your presentation, and I think we keep directly going with Ivana Kunda and her presentation, if this is fine for everybody.
Okay. Well, I'm very happy to be here today. Faculty of Louis Rijeka from Rijeka is very pleased to be working together with our colleagues in Graz, especially Philip and Eva. Thank you very much for your kind preparation of this seminar. I'm sure that Daniela has already put some of our thoughts and thanks to you guys in her introductory words, but I feel very much obliged to do so as well.
Thank you very much. We're very happy to have you as partners.
Great. We are happy to be actually following up the seminar that you have performed for Croatian practitioners in Rijeka a month ago. And I'm sorry that if there is some distraction on my part a little bit, because I'm currently not in Rijeka, but in Osijek, which is on the other part, diametrally opposite part of Croatia, where I'm attending the meeting, and I'm borrowing a room from the Osijek dean, law faculty dean. So this is not my natural environment, but I hope I'll be up to the task that's before me. I'm going to share the presentation with you right now, which I have prepared for this purpose. Okay, let's try the slideshow. Okay, can you see it? I hope so.
There is a chance that if you use the presentation this way, can we just try it out and you click one slide ahead and see if we can see it? Because before this yeah, now we can see it for some reason. Okay, perfect. That works.
Oh, well, technology is not as smart as we
sometimes there's
be. It's not on us humans at all. It has to do with technology, I'm absolutely sure. In any case, I wanted to say that I'm actually very happy to speak about European Order for Payment regulation, because it's been one of the regulations that have been a bit neglected, not as much as small claims, but a bit neglected in the national procedures, probably because there are some parallel proceedings already existing in national proceedings, and the Brussels one came beforehand and so on. So people have already become used to some other types of proceedings, and it takes time to accept some new. However, I hope that based on the previous presentation by Judge Manester, you have already seen that there are some advantages to using this procedure, and it is not very easy to keep the dynamics after this previous presentation. I hope I can do that and keep you awake still, because jurisdiction is not as interesting or funny as the entire proceedings. It's just one little segment of it. However, we can say that the regulation, which was adopted in 2006, became started to apply in the end of 2008, and in all member states except Denmark, as we heard, and it lays down the standards for uniform European procedure, creating European enforcement order for cross-border collection of uncontested debts. Unlike the usual contradictory procedures, this procedure provides for EOP to be issued without hearing the defendant beforehand as a rule. And defendant can only prevent enforceability by filing the statement of opposition. The use of standard forms is supposed to make the procedure more simple, accessible also to laymen, to parties, not without the necessity to use attorneys' help. However, that is not always the case, because if you try to fill in some of those forms, you'll see sometimes there will be some question marks above your head, thinking about what actually is required to be stated in this or that section. Furthermore, enforceable European order for payment, which is issued in a member state is considered to be an order issued in a member state in which the enforcement is requested. So this means that the claimant can directly enforce such an order in another member state. That is a great advantage when we compare to Brussels 1 this regulation, or if we compare it to the previous ones. Comparing to the Brussels 1, the advantage is that there are lesser grounds for refusal, and the procedure which is the procedure to refuse the enforcement, not the enforceability. Enforceability cannot be contested, but the enforcement can be contested on much lesser grounds than under many other instruments. So it's a measure that can be carried out directly in another member state. However, it has to be said, as I pointed out at the beginning, that this regulation does not replace or harmonize the existing mechanism which are present in member states' national laws related to the recovery of such claims. In cross-border collection of uncontested debts, claimants in other member states can choose between EOP and national procedures, depending on the subject matter, of course. So if we try to think about what are the essential elements that we want to think when we think of jurisdiction, then let's look at Article 7, which concerns the application for a European order for payment. And among other elements of the application, we can say that under A, it requires addresses of the parties. Why I'm mentioning it? Because it might be loosely related also to F, the grounds for jurisdiction. Not address of the parties is not just for the purpose of service of documents and so on, but also can be used as an element in establishing some of the criteria for the grounds of jurisdiction. And when we come to the court's role after they receive this application, then the court sees who has been submitted the Form A, has to examine this application, and among many other things they have to check is if the application falls within the scope of the regulation, including if it's a cross-border case, if the claim is about specific amount that has fallen due, and of course if the court sees has jurisdiction with regard to the application. And that's something that we are going to talk about a little bit today into more detail. As well, the court checks whether information provided is complete and correct, and if the claim is justified, taking then some of the adopting it, or if some information is lacking or needs some correction, then the court may give claimant the opportunity to complete or rectify the application within the specified time limit using Form B. And unless the claim is clearly unfounded, when it's going to be declared inadmissible. Well, this is just a little bit of review into the procedure so that we know in which of those stages we fit the question of examining jurisdiction. And what does the recital 16 tell us about the rules in the regulation? It says that the court should examine the application, including the issue of jurisdiction, on the basis of the information provided in the application form. So given that the initial examination of an application may be made by an automatic procedure in some member states, it's sufficient to verify that the indicated address of the parties is in different member states when we are talking about cross-border case. From different member states from the one of the forum of the court seized with the matter. However, if the court has doubts regarding the information that is provided, as I said, the court may invite or give the opportunity to the plaintiff to rectify or supplement or correct the information. This is a bit different from the notion of the competent court when we talk about jurisdiction, because the competent courts for EOP are those that have been designated by the member state and officially notified to the Commission under Article 29, paragraph 1, subparagraph A of the EOP regulation. What does it mean? It means that member states actually decide what courts will be handling these cases. In many countries or member states, the legislator has chosen only some courts to handle these cases. As you have seen from the previous presentation, at first those were commercial courts in Croatia, and later on this has been changed so that now municipal courts are competent courts. However, that does not mean that Croatian courts, municipal courts, always have jurisdiction. And that is actually what we are going to talk about, because member states can modify the competition question, but they cannot modify the jurisdiction because the jurisdiction is defined on EU level, while the competition within a member state falls within the member states' powers. And they can change this. It's important that when applying for an EOP, each plaintiff checks also the competition issues, whether such notifications have been given in a certain state. We have seen that's possible. It's possible to do that on the website, but sometimes the data is not fully updated. So it is important to check that as well. If the competence of the court is of a territorial nature and depends on the address of the defendant, a specific court can be found by making use of the competent courts tool in the atlas. In a few cases, member states have designated specific courts and have concentrated jurisdiction in such courts. So if an applicant submits the application to the court that is not competent, but the member state has jurisdiction, then it's a matter of national law what the court will do with this application. Will they forward it or not to the other court? Now that we have made a distinction between those two notions, and I would like to say that from now on, we'll be talking about jurisdiction, international jurisdiction, because we're dealing with cross-border cases. And in this European Order for Payment regulation is actually an element in a system of different legal instruments which have been enacted at the EU level. So it doesn't operate on its own, as you already know, or you could have imagined. It is connected with other legal instruments, because in practice, things happen on layers and in stages in which different instruments come into play. So if you choose these proceedings, it still will implicate the application of some other legal instruments, such as, for example, the service of documents, regulation on service of documents, or taking of evidence, which will be one of those discussed in more detail in this seminar later by my colleagues. And today we're going to put additional focus on Brussels 1 bis regulation, which deals with jurisdiction. And let's see, how do we get there? So first, I think we need to see that the scope of application of EOP regulation and Brussels 1 regulation do have common elements. And when I say that, I mean to say that they both apply to civil and commercial matters. And EOP regulation specifically points out in cross-border cases. It also tells us furthermore that civil and commercial matter is not dependent on the nature of the court or tribunal, because different courts and tribunals in different member states can have different subject matter jurisdiction. And it also tells us that civil and commercial matters do not include, in particular, revenue, customs, and administrative matters, or liability of the state for the acts of omission in this exercise of state authority, or what we also refer to as acta iure imperii. I also would like to add that we've seen that in the previous presentation, but it is necessary to go into more detail here just to clear the situation out, is that this regulation shall not apply to rights in property arising out of matrimonial relationship, wills and succession, bankruptcy and related analogous proceedings, social security, and claims from non-contractual obligation, unless in two specific cases. One, if they have been subject of an agreement between the parties, or they have been an admission of the debt, or alternatively, if they relate to liquidated debts arising from joint ownership of property. Those are quite narrow situations, and this means that non-contractual obligations will rarely enter the EOP proceedings. However, it's not fully excluded, so we'll also touch upon this issue as well. As we said, territorially, this regulation does not apply to Denmark. Well, let's look at the civil and commercial matters into a bit more detail. So what are the negative parts of the definition? As we already said, it excludes revenue, customs, and administrative matters in particular, but that's not all that it excludes. And so what does it mean? Revenue, customs, and administrative matter is usually somehow reminding us of the public law. However, European law never speaks of European private international law never speaks of the differentiation between private and public, because that is something very fluid, and even in national laws, sometimes it's difficult to make a distinction. Therefore, they have this special wording of civil and commercial matters, as opposed to non-civil and commercial matters. It also includes liability of the state for the acts of omission in the exercise of state authority. So while the former is the standard formulation, which we can find from Brussels Convention onwards in many different pieces of legislation on European Union level. The latter was the legislator's reaction to Court of Justice ruling in Le Hitero, which was the case related to the non-contractual liability for the acts of the army during the Second World War, which resulted in alleged damage to plaintiffs' relatives. In any case, I wanted to say that this addition, which is not present in every legal instrument that is dealing with civil and commercial matters, does not mean that it doesn't apply elsewhere too. It has just found its way to those newer legal instruments in which could have taken account of this new case. I wanted also to emphasize that the notion of civil and commercial matters is the same concept in Brussels 1 bis, Rome 1 and Rome 2, because there is a coherent interpretation between all of them. It is a single concept. There is no need to make a distinction between what is civil on the one hand and what is commercial on the other. When we say a specific legal relationship is civil and commercial matter, then we mean it as a whole. We never need to differentiate. Therefore, all the case law that we already know within any of those regulations, usually that will be the Brussels 1 bis, will be applicable all over the system of the regulations mentioned here, including European Order for Payment regulation. It is the autonomous interpretation that the Court of Justice insists on, saying that when we define civil and commercial matters, we should never look into national law, but we have to derive the meaning of this notion from the objectives and scheme of the EU legislation concerned, which is Brussels 1 or EOP regulation, and the general principles underlying the entire corpus of the EU national legal system. So something comparatively, let's say, something common to all national legal systems on the principle level. And this is how we get to the definition of it, which has been developed through many cases. There is no possibility to go into detail of these cases under this topic, so I'll just leave it to you to take a look further. So when we compared the scopes of the two regulations are similar, we can easily understand why the court makes reference to Brussels 1 regulation, but it does make it in 3 instances, 2 of which are of importance for us. First is the cross-border nature of the case, which is a requirement for an EOP regulation to apply at all. And the second is the question of jurisdiction under EOP regulation. First, as to the cross-border nature of the case, we need to take a look at Article 3. It says in paragraph 1 that for the purposes of this regulation, a cross-border case is one in which at least one of the parties is domiciled or habitually resident in a member state other than the member state of the court sees. So we see that this definition applies only for the purposes of this regulation. Brussels 1 bis has a different notion of cross-border case. We have learned from some of the Court of Justice cases that it's sufficient that only a nationality of one of the parties is foreign, that we will have a cross-border case. But it is not sufficient under EOP regulation. Here, we need either a domicile or a habitual residence in another member state, different from the member state of the court sees. So we need some inter-member state connection here between the court and one of the parties, not both, just one. So it tells us further in paragraph 2, the domicile shall be determined in accordance with articles in Brussels 1 regulation, because this was the predecessor of the now in force Brussels 1 base regulation. However, the reference now has to be understood in the sense of the new regulation. That's why I put it in brackets. And the third paragraph tells us that the relevant moment for determining whether there is a cross-border case shall be the time when the application for the European order for payment is submitted in accordance with this regulation. So this is something to remember. And let's now try to make a bit of the analysis of these provisions. So variations from the cross-border cases can be the following. Since only one party needs to be in a different member state than the member state of the court sees, we can have different combinations for plaintiff and defendant. So, for example, plaintiff who is domiciled or habitually resident in a member state different from the forum member state, and defendant who is domiciled or habitually resident anywhere else, be it the forum member state, be it the member state other than the forum member state, or a non-member state. We can reverse the situation now between the roles, the procedural roles, and have the defendant domiciled or habitually resident in a member state different from the forum member state. Well, in that case, plaintiff can be domiciled or habitually resident anywhere else, be it the forum member state, the member state other than the forum member state, or a non-member state. So we see that only one party needs to be in a member state different from that of the forum. Let's look at those criteria for jurisdiction, which are actually here criteria for cross-border cases, sorry. It's either domicile or habitual residence. Article 3, paragraph 2 tells us that we have to look for the definitions in the Brussels 1 when it comes to Brussels 1 bis when it comes to domicile, and there we find a specific definition for natural persons which refers to national laws. Then we find an autonomous definition when it comes to legal persons. And then we find also that for trusts, the national definition has to be established under the law applicable following the forum private international law rules, conflict of law rules. On the other hand, when we come to habitual residence, then we see that here we have a EU autonomous definition, which to some extent, I'm not sure we're going to talk about it, where there is a question mark when we come to some habitual residence of some parties. And also, we can say that the definition which is developed is very much fact-based, because the criteria there, they rely on the facts of each particular case. And these criteria are developed by the Court of Justice of the EU case law. So when it comes to domicile for natural persons, the EOP regulation, Article 3, paragraph 2, tells us a look at the Brussels 1 bis regulation. And in particular, we have to look at Article 62. Paragraph 1 tells us that in order to determine whether a party is domiciled in a member state whose courts are seized of a matter, the court shall apply its internal law. Okay, this will rarely actually be relevant because we usually want to determine that a party one party is domiciled in another member state. So how do we determine that? Not in a foreign member state, because we don't have cross-border case if not at least one of the parties is domiciled outside the foreign member state, in another member state. Then comes paragraph 2, which tells us, if a party is not domiciled in the member state whose courts are seized of the matter, then in order to determine whether the party is domiciled in another member state, the court shall apply the law of that member state, that other member state. So it's very simple to determine whether, if we are sitting in Austrian law, in Austrian court, to determine whether one of the parties is domiciled in Croatia, we need to apply Croatian law. And if the situation was different and we were Croatian court and trying to establish if we have a cross-border case and everything else is connected to Croatian, however, there is a claim that one of the parties has a domicile in Austria, then we will apply Austrian national law to determine whether domicile is really there. So it depends on the national law. So reference in Article 62 is to internal law of the member state in which the domicile is claimed to be located. If we combine the two paragraphs, then we see that it's always the internal law of that member state in which domicile is claimed to be located, for which we are testing the domicile. It's in a general report, there has been a statement that we should not automatically conclude that domicile is the same as legal fiction of address for serving documents. That's natural. That's something that courts already know, I suppose. It's nothing new. However, it needs to be stated clearly, because previously I mentioned address. So address can be an indicator of where to look, into which law to go and look for, but not basically enough to conclude. So if you only have an address, that could not lead you to a justified conclusion that there is a domicile there. And when do we do a certain domicile? As already said in paragraph 3, analogy has to be made to the principle of perpetuatio fori or perpetuatio jurisdictionis, which ties the jurisdiction to the moment when the proceedings have been instituted. In paragraph 3, the nature of the cross-border case is tied to the moment when the proceedings have been instituted. So that is the decisive moment. Later change, according to this, should not affect the case. However, we can ask ourselves the question, what if at the moment when the proceedings have been instituted, there was no cross-border case, but by the time you're making an assessment, there is a cross-border case because one of the parties domiciled or habitual residence has changed? Does it make sense to declare this a cross-border case? Well, from the practical point of view, I suppose that would make sense. Because otherwise you would deny the parties a chance to litigate further, but actually it doesn't make much sense from the efficiency point of view or the parties' interests in completing the proceedings. They would still be able to later on go into the same proceedings. Perhaps they could be barred by some other things, like statute of limitations or so on. However, it doesn't make much sense. On the other hand, if the things change to the worse, I mean, from cross-border case to non-cross-border case, that perhaps could not have been reasonably foreseen by the parties, that this could happen, and to the plaintiff in particular, that this could happen and actually make it more complicated for that party to keep on. But it's for the courts to actually look at this special question once it comes up, if at all. Perhaps it's just a hypothetical thing that I have come up with thinking, looking into these provisions, and it might not be at all relevant for the practice. But when it comes, if it comes, then it's actually for the courts to see how much sense does it make either to not say it's a cross-border case or to say it's a cross-border case. I always think it's good for the courts to just take a look at 1 or 2 steps ahead. What will happen if I do this? And what is potentially going to happen if I do the other thing? And then conclude how much sense does it make from the perspective of parties' expectations, procedural efficiency, and all other matters that courts are usually very much aware of. Let's take a look at the domicile for legal persons. That is in Article 63 of the Brussels I-bis regulation. And Article 63 tells us an interesting thing. It tells us that the European Union legislature decided that they want a single definition of the domicile for a legal person. They don't want to make the reference to national laws, as they did when it comes to natural persons. So, for the purposes of this regulation, Brussels I, but also EOP, because there is a reference, a company or other legal person or association of natural legal persons is domiciled at the place where it has its statutory seat, central administration, or principal place of business. Either of the 3 things. We need to remember this, but we're going to come back to it in the next slide. Let's just go to the end of this article to see the complete picture, because it says that for the purposes of Ireland and Cyprus, I omitted UK because it's no longer important. Statutory seat means the registered office, or where there is no such office anywhere, the place of incorporation, or where there is no such place anywhere, the place under the law of which the formation took place. This is because those jurisdictions do not know of the notion of statutory seat, which is very well known in most other member states, and that's why it's chosen here. Paragraph 3 tells us that in order to determine whether a trust is domiciled in a member state whose courts are seized of the matter, the court shall apply its rules of private international law. And this is probably the most conflict of law natured reference there can be, because the domicile of trust needs to be determined by first subjecting the trust to the private international rules, then deciding what law applies to determining the domicile of the trust. So that is quite of a complicated exercise, but usually not very common, at least not in the jurisdictions such as Croatia. Let's take a look at the Article 63 in more detail. Definition that we see in paragraph 1 is an autonomous definition of the domicile for legal persons. It is completely independent from the national notions, both in selection of criteria and in defining these criteria. What we see from this wording is that those 3 criteria are exhaustive. We cannot add another one. Those 3 are the only criteria that we can take into account. However, having said that, there are also alternative criteria. So either of them can take us to the domicile. They're not cumulative. They don't apply altogether. You can have a domicile in a member state under either of them. So that means that a particular legal person may have maximum of three domiciles, three different domiciles, and those can be in different member states. So we can have domiciles in three different member states, theoretically. That doesn't happen often. It can also happen that the only one is in a member state and two are in a non-member state, or two are in a member state and one is in a non-member state, or whatever combination there are. As long as at least one is in a member state, that legal person will have a domicile in a member state. So in case of cross-border cases, the question may be asked, if under Article 63, a company has, for example, a statutory seat in a foreign member state, but a real seat or central administration in another member state, is the cross-border requirement fulfilled? That is an interesting theoretical question. I don't think it comes up quite often, but it might be because you might be interested in claiming that. So that is something that has not received an answer yet, I suppose, and it could be discussed further. I haven't found any reference to it in the literature either, so it's just something that comes up when you look at the and you're trying to make a puzzle complete. You see that there are some pieces that do not always fall in its place as you expect. In any case, when do we assess, as to what point do we assess the domicile for legal person? It's the same as for natural persons at the moment when the proceedings have been instituted. So it's an analogy to the perpetuatio fori situation for the jurisdiction. Okay, let's see a bit of detailed analysis as to the what does it mean, each of those criteria under Article 63, paragraph 1. Statutory seat, as you already know, and that's the most common notion, is the place where a company, for example, is incorporated, or another legal person is established, or the place which is named as statutory seat, or a seat in its articles of incorporation or statute, or a company register, or a different public register if it's not a company. So this is something that is common for legal persons, because their coming into being is very much related to some act that has to be adopted and perhaps registered. And in that act, you will state which is the seat, where is the seat, and also that could be registered in the public register. In specific rules are for Ireland and Cyprus, as I said, because they don't know this notion. So we apply paragraph 2 when we define statutory seat for the Ireland and Cyprus. B is the central administration, which is the real seat, which is the actual place from which the company is managed and controlled. And establishing this does not depend on looking into public register or NAC. It's not a formality. Establishing central administration is a matter of fact. Sometimes these facts will not be known to the plaintiff or the other party, but if they are known to it, then they can make an argument based on it. The same is with principal place of business, because it also depends on the facts of the case, where the main business activities are located of the company. Sometimes this C will not be applicable at all, because business activities can be dispersed in different member states, and in neither of those it is a place of main business activities. But in most of the cases, that's not true. Usually, those three will be in the same country, but sometimes not because of some tax treatment issues or other issues. There might be separate. Okay, so let's now take a look at the other criterion of habitual residence. When it comes to natural persons, we're going to again start with natural persons. Unlike for domicile, we have a autonomous definition of habitual residence for natural persons. That means we don't look at national laws, we look at EU law only to see what is habitual residence, what that notion means. And it's been mostly discussed within the family matters. When the Court of Justice was called to interpret that notion in the context of Brussels to this regulation regarding divorce and parental responsibility mostly. Well, the court said, besides being autonomous, this notion is based on facts. There is a factual assessment by the court of the criteria provided by the Court of Justice in its case law. Also, at the time, the moment when the proceedings have been instituted is important. So let's take a look. What are the criteria that we need to observe? So habitual residence for natural persons is usually established based on two basic criteria: physical presence at the territory of a specific member state and intention to remain there. That comes from the case A, which was decided, in which it was stated that in addition to physical presence in a member state, other factors must be chosen which are capable of showing that the presence is not in any way temporary or intermittent, and that the residence reflects some degree of integration in a social and family environment. So this case was decided based on the child's habitual residence, but the similar concept is very much the same for adults as well, because there is a need to show physical presence and integration and intention to remain there, which both have to result and show that there is a integration in the social environment of the country. Family is added here because children mostly integrate within a family, not just the social community. So what we can say is that that when we compare the physical presence and intention, it becomes evident that the former is more of an objective criterion, while the latter is more of a subjective. Physical presence is mostly easy to prove. It's not that difficult, but intention is difficult to prove and relevant only where it may be substantiated by tangible steps taken by a party. What does it mean? The court specifically says they have to be tangible elements, something materialized. Intention, as you say, oh, I do intend that this happens, is not enough. There has to be something in particular, which shows that intention actually existed, some proof of intention. For example, that can be a lease, like a mid-term or long-term lease of an apartment or similar things. And mere party statements will not suffice. When party states to have had an intention to move abroad or not to reside in a place, they cannot point to tangible steps. That would not be enough for the court to believe that there is habitual residence. The intention will remain not proven. This is very much related to legal certainty, because interpretation to the contrary would jeopardize the predictability for the other party. And however, if the intention is not very strong, long physical presence can be sufficient to prove habitual residence. So we have to balance between the two criteria. If one is weak, the other may be compensated by the strength of the other. So also, very short physical presence can be compensated by a strong and proven intention of the party. So, for example, we see from the case law of the Court of Justice that there is no minimum time requirement for a person to be present in a state that there is habitual residence. They may acquire habitual residence within just one day, actually. And the physical presence and intention there have to be balanced, or they can compensate for each other. In this case, we can conclude in favor of the other, even if one is very, very much weak. Such would be the situation in which a person has just moved from one country to another, which was well illustrated in the Court of Justice case of Mercredi, where a small child has just moved to another country, but the mother has actually disconnected from the previous country, and all what she has done was a clear indication that she had a strong intention to remain in the new country. So the fact that the dispute has started just soon after they moved does not mean that habitual residence cannot be established. And that is something that the Court of Justice case law teaches us. However, there is something that is not very clear to me, at least. Do we have habitual residence for natural persons? Because it is not in Brussels 1. If you remember previously, we have had a reference to Brussels 1 in Article 3, Article 3, which said that we need to determine domicile on the basis of Brussels 1 regulation. But can we apply Rome 1 regulation for the purpose of habitual residence? Or shall we remain, when it comes to habitual residence, only to natural persons and not even look at the habitual residence for legal persons? Sorry, there is a mistake here. I have to correct it. Habitual residence for legal person there is not natural person acting in the courts of business and legal person. Sorry, I made a mistake in the green part here. So we have to actually try to look at this from this perspective, because maybe it can be used, although I'm a bit skeptical about this, because there is no clear reference to where do we get the idea of what is habitual residence. For domicile, it'll tell us Brussels 1, but for habitual residence, we have no instruction in EOP. Does that mean we can choose anything? I suppose. What do we have for legal persons? Because habitual residence, there can be a habitual residence for legal persons, as we can see from Rome 1 regulation. Article 19 tells us that for the purposes of that regulation, habitual residence of companies and other bodies is place of central administration. Okay, that does not give us much more than we already have, because we know that place of central administration is one of the elements in the definition of domicile. So we don't get anything from this. However, we can have something from habitual residence of a natural person acting in the course of his business activity, which would be principal place of business. And Article 63 in Brussels 1, this regulation applies only to legal persons, not a natural person acting in the course of business activity. So this would be an added element for assessment of habitual residence of natural persons who are sued or are plaintiffs or defendants in the capacity, in their business capacity. So can we rely on that? I don't know. That's one possibility. And there are other elements here to be taken into account from Rome 1, which says place where the when it comes to operations of a branch or agency or other establishment, we have also additional element for the branch, agency, or other establishment is located, which was not mentioned before. So these two additions perhaps can be used, but also another difficulty is that they are relevant at the time of the conclusion for the contract for the purposes of this regulation. Is this time also relevant for the purposes of another regulation, which is not applicable law, but procedural regulation like EOP, to match better the situation in Brussels 1? Or should we forget about this fully? That's an interesting point. And I think that if we forget about it, then what is left? We only have habitual residence for natural persons in EU law defined. But what about habitual residence for legal persons? How do we define what's that? Well, if we don't take Rome 1, then we have to go to national laws and define habitual residence under national law. Is that something that we want or not? Well, I do not intend to impose any of my opinions upon you. I have just wanted to open some gates, open some windows, perhaps that can be tested to some point in the courts. That's something that the attorney's creativeness can be aimed at, and perhaps trying to do something with that. Not sure how much is that useful. Are they willing to fight so badly for EOP proceedings? I'm not so sure that they want to make all these constructions. However, it was interesting for me to see, at least, and I hope at least to some of you it could be of some interest. Okay, if we set aside these questions, then we can now finally turn to the questions of jurisdiction that are in focus at this point. And when we come to jurisdiction, Article 6 of EOP regulation tells us that for the purposes of applying this regulation, jurisdiction shall be determined in accordance with the relevant rules of European Union law, in particular regulation Brussels 1 bis regulation. Okay, so any rules, but in particular Brussels 1 bis regulation. So if the claim, however, relates to a contract concluded by a person, consumer, for the purpose which can be regarded as being outside his trade or profession, and if the defendant is that consumer, only the courts of the member state in which defendant is domiciled within the meaning of Article 59 of the Brussels I regulation, this regulation, shall have jurisdiction. So we have one general rule referring us when it comes to jurisdiction to Brussels I bis regulation, and a special rule below, which is actually telling us what to do if the contract is a consumer contract and if defendant is the consumer, if the consumer is the one sued. How to determine jurisdiction. Okay, so let's go first into the special provision because it has, as lex specialis, it is more important to define it, and it's actually specifically regulated in the EOP regulation. So in Article 6, paragraph 2 of the EOP regulation, jurisdiction for consumer contracts is somehow limited in scope and in criteria. Definition of consumer contract is the same as in Article 17, paragraph 1 of the Brussels bis regulation. It's a contract entered for the purpose which is outside profession of the trade of that party. However, Article 17.1 of the Brussels I bis regulation poses further requirements for application of this protective section 4, which are not imposed here. So what we see, and we can ask ourselves, are these requirements applicable at all? Because they're not stated here, and the definition is. If they are not applicable, then the scope of the consumer protection under EOP will be wider because it will include more consumer contracts, not only those under Article 17.1, which are restricted to only some consumer contracts, such as sale of goods on installment credit terms, or a contract for loan repayable by installments, or for any other form of credit made to finance the sale of goods, or in all other cases, the contract that has been concluded with a person who pursues commercial or professional activities in the member state of the consumer's domicile, or directs such activities to that country only or among other countries also to that country, and the contract falls within such activities. Those are the restrictive elements of Article 17.1, which I suppose are not applicable in Article 6, paragraph 2. To have this paragraph applicable, we only need to see that this is a consumer contract, which is a contract concluded by a person for the purpose regarding outside his trade or profession. The other requirement that we need for Article 6, paragraph 2 to apply is that that person, the consumer, is in the procedural position of the defendant. So he is not plaintiff. He is not the one or the applicant. He is not the one instigating the proceedings, but the one against whom the proceedings have been commenced. If we have those two requirements, it's a consumer contract, and the consumer is the defendant, then we come to the exclusive jurisdiction of the courts in the member state in which defendant is domiciled. And because this is the consumer contract, the domicile can be only of the natural person. We know the definition of the consumer in European private international law includes only natural persons, not legal persons or any other types, which can be just natural persons. And in such case, what do we apply? Article 62 of the Brussels I bis regulation to define where the domicile of that dependent consumer is. So we apply the substantive law of the member state for which the domicile is ascertained, for which we claim that the domicile is located there. And that would be, in this case, the law of the forum, usually, because the plaintiff will claim, yes, I base this jurisdiction on Article 6.2 because defendant is domiciled in the forum state. Or if the defendant raises an objection, they will usually say, oh, I'm not domiciled in the forum member state. And because this is exclusive jurisdiction, you have to verify that I'm domiciled in another member state, or at least that I'm not domiciled in the forum member state. You don't have to say where else. Okay. That would be relevant for the cross-border case, perhaps. So the special provision in Article 6.2, if we want to make a little bit of recapitulation, is based on defendants, consumers, which is determined under substantive law of the member state for which domicile is asserted. And the concept of consumer's domicile in Article 18, paragraph 2 of the Brussels of the regulation is to be interpreted as designating consumer's domicile at the date on which the court action is brought. That was stated by the Court of Justice in M-Bank case, which was more recently decided. And so we see that the perpetuatio jurisdictionis applies here as well, although not particularly mentioned in the provision. We can make the reference by analogy to other instruments which speak of consumers' domicile, such as Brussels 1bis regulation. And also interesting is the Court of Justice decision in Lindner case. I think both cases actually concern some Czech banks, Czech loans, and so on. So I suppose people there are generating very interesting cases for private international, at least in this loan consumer loans section, as well German cases relating, or German-Austrian cases relating. I remember at some point also related to some other consumer issues with promises and awards and so on, some 15 or so years ago, 20 maybe. In any case, this case, Lindner, was decided under Brussels 1 regulation, but it's relevant as well now. And the court said that this regulation should be interpreted that in a situation in which a consumer who is a party to a long-term mortgage loan contract, which includes also the obligation of to inform the other party of the contract of any changes of address. You can imagine such clauses usually appearing in loan contracts, and the bank wants to make sure that the borrower, the other side, the consumer, tells them if they change the address. Such claim was not complied with by the other party. The other party changed the address without informing of where its address is. And in that cases, the other party renounced his domicile in breach of his contractual obligations. In such situations, the courts of a member state in which the consumers had last known domicile, pursuant to Article 16.2 of that regulation, which will continue to have jurisdiction if they don't manage or they are unable to determine where is the current domicile of that person, because there is no firm evidence allowing them to conclude the defendant is in fact domiciled anywhere within or outside the European Union. They just know where last the person was domiciled, but not currently. So that was the situation in Lindner case, which could be important to be mentioned in this context. So now that we've dealt with paragraph 6.2 and the most relevant jurisdiction criteria, the Brussels 1 bis, have to be talked about as well. I mentioned some of them here, which you can take a look at, but that's like a whole bunch of different criteria. Some will come up more often and some almost never, but let's go and see what's ahead. So first, let's take a look at general jurisdiction. Although general jurisdiction is not the highest in hierarchy, it is probably the most commonly referred to. It's in Article 4, paragraph 1, and it says that persons domiciled in a member state shall be sued in the courts of that member state. So it is a domicile of the defendant that is the criterion for jurisdiction, and according to the principle of actor sequitur forum rei, which is well known in most jurisdictions as well. What we see here is that no other element of the case matters. Not the nationality of either party, not the domicile of the plaintiff, nothing else is relevant except the domicile of the defendant. And what else is to be seen is that it is supposed to be determined according to the principle of perpetuatio fori, because the change of the defendant's domicile after the proceedings have been instigated does not affect the jurisdiction of the court. So only the defendant's domicile at the time when the proceedings have commenced may result in jurisdiction of the court. Besides this general jurisdiction, we have special jurisdiction in Article 7, Brussels 1 bis. That is actually, I see that I don't have a light. I will just turn on the light to be. Sorry, I hope it's better now. Article 7 gives us 7 different types of special jurisdiction based on different types of legal relationships. Unlike Article 4, which does not differentiate between legal relationship and any legal relationship as a rule can be subject to Article 4, here we have different legal relationships that we can use. So, for example, in matters of contract, what will be the place where, what courts will have jurisdiction? It's the courts of the place of performance of the obligation in question. In matters of tort, place where the harmful event occurred or may occur, and so on and so on. Some of these will be more often used in such cases such as EOP proceedings. Some are completely irrelevant because if you look at the form, for example, a recovery of the cultural object, that has nothing to do with our case. But for example, a case regarding operations of a branch, agency, or other establishment in 5 can be relevant because even though a party has a domicile in one member state, as the opening sentence tells us, it can be sued in another member state where there is a branch which was relevant for the contract, for example, or so. Okay, so let's take a look at the most common situations. And so, for example, a person domiciled in a member state may be sued in another member state when it comes to contracts where the obligation in question is performed. But there are special rules in B which tells us, oh, but the obligation in question is performed here when it comes to sale of goods. Where is that? Where the goods should be delivered or are they delivered? And for provision of services, where the services were provided or should have been provided. C, I don't see a point in C because it only says, okay, B does not apply, A apply, but that's so logical because B is specialis and A is generalis. That's something that we already know. But anyway, doesn't hurt saying it again. And for example, tort, we said only a couple of cases of tort could be relevant, but let's just try to differentiate 1 and 2. Matters related to a contract, matters relating to a delict or quasi-delict. Both of these notions are subject to autonomous interpretation, with no resort to national law, but slowly to EU objectives and scheme and general principles of EU national legal systems. What's important here to say that matters relating to contract and matters relating to delict or quasi-delict are complementary. They form a common unity. When they are joined together, they form a common unity of obligations. So if an obligation is not matter relating to a contract, then it has to be a matter relating to delict or quasi-delict, and vice versa. How do we differentiate them? Well, the Court of Justice tells us what to do. First, contractual obligations are, according to the court in Hanpe case, obligations freely assumed by one party towards the other. We see there, they don't have to be mutual. It can be a unilateral promise to be a contract under EU private international law. That's a special definition. It doesn't comply, for example, with Croatian definition of the contract. But that doesn't matter for the purposes of European private international law. Also, disputes concerning validity or existence of the contract fall under the contractual obligations. So even if the court in the end concludes, no, there is no contract, this court will be the court competent for the contractual matters. And non-contractual obligation, how is that defined? In case Calfelis, it's the action which seeks to establish liability of the defendant, but is not related to a contract, because there is no obligation freely assumed by one party to another. That definition includes all kinds of liabilities, objective and subjective, and also includes obligations arising out of dealings prior to the conclusion of the contract, so pre-contractual obligations. Unless there was a contract there, pre-contractual contract. But if there was no agreement during the negotiations, then it's pre-contractual obligation of non-contractual nature. So how do we get to what court has jurisdiction? For sale of goods or provision of services, it's the place where the goods were delivered or services were performed, or should have been. This jurisdiction is constant and it sticks with the same court regardless of the obligation which is under dispute. Is it the obligation of delivery, for example, or the obligation of payment on the other side? Because in the sales contract, we have delivery and payment. Regardless of which of those obligations is disputed and subject to the is actually subject to the dispute. The jurisdiction is always within one court only, where the goods were delivered, the place of delivery, or the place of performance of the services. And this is based on factual circumstances. So what, for example, what does the contract say? Where is delivery supposed to happen if there was no delivery? Or where it actually happened if there was delivery? However, when it comes to other contracts, which are not under B, sale of goods and provision of services is 7.1b. Other contracts is 7.1a. And what is the criterion there? It's the performance of the obligation in question. So if we look at that, then we see that in all other cases but sale of goods and provision of services, it's the obligation in question. This varies from situation to situation. And maybe one or the other obligation of one party or the other. And this may cause changes in which court has jurisdiction to determine the case. And to determine the place of performance of the obligation in question, we have to look at the law applicable to the contract, pursuant to private international law rules, conflict rules, which are for contracts in Rome 1 regulation. And then we see what law is applicable, then we look at that law, then we see where was the place of performance of the obligation in question, and then we can decide if the court has jurisdiction or not. This is insane. This is Thessaly doctrine, which is completely insane, that you have to solve the case basically before knowing if there is jurisdiction at all. Well, I'm exaggerating a little bit, but at least if you compare sale of goods and provision of services to other contracts, you just can't really realize why is that so. And that is so because of the historical reasons, because first there was light, and the light was other contracts, but then they saw there was more light, and that was the sale of goods and provisions of services, which they added later on. So, well, now there is darkness on the other contracts and sale of goods and provision of services where we see more light. But anyway, jokes aside, it's the situation which differs depending on the type of contract, and one has to bear that in mind. When we come to non-contractual matters related to non-contractual obligations, matters related to delict or quasi-delict, tort or delict or quasi-delict, the criterion for jurisdiction is placed where the harmful event occurred or may occur. And according to the Court of Justice of the European Union, we have to apply the ubiquity theory here, because this includes both the place in which the event giving rise to damage occurred and the place in which consequences of that event occur, and only direct consequences, as the court later on cleared out. At the beginning, they only said consequences, but later on we learned from the case law that only direct consequences come into play. So those are the two courts which the plaintiff can choose between the two of them. It's at the choice of the plaintiff, the court says. It's no need to choose one over the other, or there are no specific preferences among them. So if we look at now, if we look at this, there is a lot of case law behind this Article 7.2 as well as 7.1. So if you need to apply these in particular circumstances, please take a look at the case law, because that will open up a whole new world to you, which is not really visible only from those words. Article 8 also hides some of the special jurisdiction criteria. For example, where there is several defendants that are sued at the same time, and there can be an attraction of jurisdiction, as we call it, jurisdiction by attraction, so that only one of the defendants is domiciled in the forum state, others are attracted to that, provided that claims are so closely connected that it is expedient to hear and determine them together to avoid the risk of irreconcilable judgments resulting from separate proceedings. this is a very interesting concept, which has also been discussed by Court of Justice. It's not necessary that we enter into this discussion, but to know what that actually means, it would be good and advisable to look at some of the case law. There, for example, there is a Tatri case relating to some non-contractual obligations and contractual obligations, actually. And then we have a third party. So the person may be sued as a third party in the action on a warranty or guarantee, or in any other third party proceedings before the court of the original proceedings. Unless these were instituted solely with the objective of removing that third party from its national jurisdiction, its jurisdiction which would be somewhere else. So that party can prove that it's only the reason why others are sued that they can be involved in the case. And there is also a counterclaim option here. Okay, let's now look at the protective jurisdiction criteria, because Brussels I regulation provides for 3 categories of protective jurisdictions: insurance, consumers, and employment relationships. So in Article 11, there are a couple of articles. I just went to the most important ones, skipped some, but they're not to be skipped when you're deciding where to sue. This is just an illustration. The insurer domiciled in a member state may be sued in the courts of the member state in which he is domiciled. So this is similar to the Article 4, paragraph 1, or the same. But it can also be sued in the claimant's domicile. So we see that forum actoris is appearing here. Or if he is a co-insurer in the member states where the proceedings are brought against the leading insurer, usually because he's domiciled there, or where the claimant is domiciled, that can be the case. But that could be important when where the other insurer, leading insurer, is domiciled. And this provision also extends the scope of Brussels I regulation to persons not domiciled in a member state who are insurers. And if they're not domiciled in a member state but have a branch, they can be, or other type of establishment, they can be sued in the place of such branch in a member state, provided that the dispute concerns the operations of that branch. Because, for example, insurance contract was concluded through that branch. That is not uncommon at all. So this brings in even the entities which are domiciled or outside member states into the jurisdiction of the courts of a member state. Now we can turn to Article 14, which says where insurer may bring proceedings against weaker parties, which is a policyholder, the insured person, or a beneficiary, only where the defendant is domiciled. So only in the domicile of the weaker party. Okay. If we further go to Article 15, we see that departure from the above provisions is not possible except under these very strict conditions. So prorogation of jurisdiction or choice of a court is only possible after the dispute has arisen without further restrictions. And if before the dispute has arisen, then if it allows policyholder, the insured, the beneficiary, so weaker party, to bring proceedings in a court other than those indicated in this section, but as an addition, not depriving the party of these courts' jurisdiction as well. And so on. So there are other, if they are both domiciled if it relates to compulsory insurance or movable property insurance, then it can be also there can be also a choice of court agreement with a policyholder who is not domiciled in a member state, and also if it covers one or more risks set out in Article 16, which are not that specifically protected. Let's go further to consumer. If you remember, one aspect of jurisdiction for consumers is particularly defined in Article 6, paragraph 2, but if there is a consumer contract and the consumer is not a defendant, then some elements of Article 17, Brussels 1 bis apply. As I said, those other requirements need to apply for Article 18 to the grounds for jurisdiction. That is a sale of goods on installments and so on and so on. And in such cases, a consumer who is not a defendant but a plaintiff, of course, may bring proceedings against the other party, either in the courts of the member state in which that party is domiciled, so this is the defendant's domicile, or where the consumer is domiciled, this is plaintiff's domicile. So he can choose either of those. This is additional when the consumer is the plaintiff, not the defendant. Okay. And these are the requirements under Article 17. I stated them here so that it becomes clear what has to happen. And also, in such situations where the consumer is plaintiff and Article 17 requirements are met, choice of law can be made only under one of these specific requirements, either after the dispute has arisen or allows consumer additional courts where they can sue, or they are domiciled or habitual residents in the same place, in the same member state. When it comes to employment relationships, Article 22 says that the employer may bring proceedings only in the courts of the member state in which the employee is domiciled. So this is protective of employees. While when we come to employee suing employer, then we see that there are more options. So the employer may be sued where the employer is domiciled, or in another member state where the employee habitually carries out the work, or where the business through which employee was engaged is or was situated at the time. Okay, so those are alternative options for the employee suing employer. Employer suing employee, it's only one. It's the domicile of the employee. When it comes to employer who is not domiciled in a member state, Brussels 1 also extends the jurisdiction according to point B, so other member state, because A is obviously not fulfilled, it can't be. Also here, we can see that this concerns only individual contracts for employment, but some other options are possible. Article 6 points to national law, point 5 of Article 7 branch, and point 1 of Article 8 multiple defendants. So we always have to take a good look at the provisions and see, because not everything is spelled out specifically. Something is just done by reference. When employee and employer want to conclude a choice of law agreement, then these are the possibilities, only two options, either after the dispute has arisen, when it's hard to agree on anything, but also which allows the employee to bring proceedings in additional member states. Let's take a look at Article 24. this is hierarchically the highest positioned jurisdiction because it's exclusive jurisdiction. It applies regardless of the domicile of the parties or any other thing. It applies only regarding the criteria that are mentioned there. And what can be relevant for this EOP proceedings is the tendencies of immovable property, mostly. There, the courts of the member state in which the property is situated are exclusive, have exclusive jurisdiction. However, in the proceedings where that have object tenancies or immovable property complete for temporary private use for a maximum period of 6 consecutive months, and tenant is a natural person, landlord, and the tenant domiciled in the same member state that also defendant's domicile can shall also have jurisdiction. So definitely the forum situs, but also the forum domicilium. Okay. Now we go to prorogation of jurisdiction, because parties can agree also that some courts have jurisdiction. If they do agree that that is the court of exclusive jurisdiction, in that only that court has jurisdiction, no other courts. So they derogate the jurisdiction of other courts under the Brussels 1 bis, and there are some formal requirements for such an agreement. It has to be in writing or evidenced in writing, which is also when it's electronic, concluded by electronic means, or in form which accords with the practices which the parties have established between themselves, so inter-party practices, or practice international trade or commerce, agreements in international trade or commerce. They can be in the form which is according to the usage of the parties in such sector. Okay, so when prorogation happens, it has precedence over other cases, apparently. And then we can also come closer to the end by also saying that what can happen is also that the defendant enters an appearance, and by that tacitly accepts the prorogation of the court's jurisdiction, even if there was no jurisdiction previously. Sorry. There was no jurisdiction previously existing in this context. Okay. I think that this closes my presentation, and if there are some questions, I would be more than happy to answer.
Well, thank you so much, Ivana, for walking us through so many problems of international jurisdiction. I'm even teased to say all problems. I'm not sure. It was such a broad walkthrough, and also through the cross-border nature of a case, and also for pointing us some interesting pitfalls that some of us might not have noticed before. Thank you so much. So, ladies and gentlemen, please use the opportunity to ask questions to Professor Kunda if there are any open questions. And there is no need to be shy.
As you said, I was so exhausted, maybe a bit exhausting too.
Don't worry, it was very interesting, and it's also always good to. I mean, I suppose many people have already heard some of the things you said, but it's always good to know, or good to get into it a little deeper again. If there are no questions for now, Professor Kunda will be still here, I think, even today and tomorrow, definitely again. And I would suggest we take a little break before continuing with Daniela's presentation, if this is okay for everybody. I would say 10 minutes. Yes, we can, Ivana, if that's fine for you, we're going to send out the presentations to our attendees.
Sure. If you want, I can make those 2 corrections and then send a new one, because I noticed that. Well,
I mean, please do not feel obliged to.
Those are minor things. I'm sure everybody.
Okay. Cool. Thank you so much.
Welcome.
Then I would suggest we take a 10 minutes break and we resume at 6:40 with our last presentation of today from Daniela. Thank you, and see you in 10 minutes. Bye.
The European Order for Payment. So Mrs. Garriga, a Spanish national, who is domiciled in Madrid, owns a coffee shop there. And in April 2018, she ordered paintings for the coffee shop from the Italian painter, Mr. Pasquale, who is domiciled in Trieste. Mrs. Garriga pays the price, but the paintings never arrive. And in May 2018, Mrs. Garriga decides to apply for a European order for payment before the Spanish court. So, what should Mrs. Garriga do in order to obtain European order for payment? So, what would be her first step? Okay, so as it was already.
I mean, Daniela. So the question is how we're gonna do that. But I can always step in. We can like. I'm not sure this is what you are intending though. You can just solve the cases.
Yeah. Okay.
If you like, or do you want me or Eva to work with you together and like?
No, I mean I can provide the answers right away.
I know you can. I know you can. Of
You
course.
can step in if you want to add something or comment. Yeah, that would be great.
Sure. Okay.
Okay, so basically we have heard from the first presentation by the Judge Manestar that European Order for Payment Regulation is annexed with several forms. So in order to obtain European Order for Payment, the first step would be to fill in the application form A. So maybe I can share it on the screen. Let me just move to the. Okay, I'm not sure if you're seeing.
I think it's
The
about to
later.
share. Yeah, we can see it now. Perfect.
Okay, let me just move to the. End of. So Form A is placed in Annex 1. And at the end of this annex, there are guidelines for filling in the application form. So the guidelines suggest the parties, actually to the plaintiff, which information should be filled in and how should this information filled in. So it is basically what is prescribed by Article 7 of the European Order for Payment. So the parties have to decide, or more precisely specify, on which basis is the court's jurisdiction based. So they have to specify the article from the Brussels 1 bis regulation. We have heard a detailed analysis of the applicable provisions by Professor Kunda. Then the application form needs to contain information on parties and their representatives and details on that, as well as whether the case is actually a cross-border one. This is rather important, since the element of the cross-borderness is defined by a European Order for Payment regulation, as well as the small claims procedure regulation, as we will see tomorrow. And whereas for the purposes of the Brussels 1 bis regulation, we don't have such a definition of a cross-border case. So when a court has to apply Brussels 1 bis regulation, it does not have specific guidelines as to whether there is an international element. except for maybe the Lindner case, which was presented or mentioned by Professor Kunde, in which the court specified that if the only element in a case is the fact that one of the parties has a different nationality, this should suffice for the case to be a cross-border one. Then furthermore, let's get back to the application form A. The plaintiff has to give the bank details. He or she must specify the claim as well as the interest and so on, as well as the costs. Also, evidence should be specified and additional information if this is necessary. So also, Mrs. Garriga would have to check on e-justice portal, which was also mentioned, what is the acceptable means of communication in a particular member state. So let me just go to e-justice portal. I hope you can see it.
You can see.
Okay, great. And then there is a part of the website which is dedicated to European payment order. And then if we scroll down, there are notifications of the member states and search tools helping to identify competent courts, but not only competent court, but also other information such as which is the accepted communication means. So let's say that Mrs. Garriga wants to apply before the Spanish court, then we would check Spain and see what is the accepted means of communication. So here it says it's directly, the application form has to be lodged directly by post or by fax. However, one should be careful when checking the information on e-justice portal, since it is not always accurate. So
Has this happened to you before, that like you found some information that was not accurate? Because you've said that before, or I think Ivana said that before, that it could happen that it's not accurate. I mean, I've not heard that before, but has it happened?
yes, I will try and find this information.
You don't, I mean, not necessarily to show us the information that is wrong, but like I'm actually worried because like from what I know, this portal is a very potent tool actually.
Yes, it is, but I think for Croatia, as Judge Manester mentioned, with the newest amendments to the civil procedural rules, it used to be the jurisdiction used to lie exclusively with the commercial court. And now it was actually transferred to municipal courts.
Mm-hmm.
So you can see here, if you can see the information for Croatia, that it still says that commercial court in Zagreb decides on applications. However, this is changed. So I would check just in case with regards to information provided by the e-justice portal. And sometimes even the original language version provides different information than the one translated in English. So I have come across a situation in which, I'm not sure for which country, it doesn't matter, but in the original language, the information was different. And when you consult the same page in English, there was even a note saying that translators are actually working on it and that the original language version is the more accurate one.
Okay, that is actually very good to know. Thank you.
You're welcome. Okay, let's get back to our hypothetical case. So with this, we answered the first question. So the second one is the Spanish court. Let's suppose that the Spanish court issues a European order for payment. And while Mr. Pasquale was on vacation, the order was served to Mrs. Gatti, who is his assistant employed in his gallery. Unfortunately, she forgets to give the order to Mr. Pasquale. Is the service of the European order for payment in accordance with the regulation on European order for payment. So this question refers to service, and for answering it, we should consult Article 14. So basically, we will talk about service tomorrow in more detail, but for the purposes of the European Order for Payment Regulation, there are three types of services. The first type is regulated by Article 13, which talks about service with proof of receipt by the defendant. The second type would be regulated by Article 14, service without proof of receipt by the defendant. And then finally, the third type, let's say, is the one specified in Article 15, when the service is done on a representative of the party. In question 2, in this variation of facts, we need to consult Article 14, since the service to Mrs. Gatti would actually fall into the ambit of this provision. And if we take a look at paragraph 1, point B, it says that in the case of a self-employed defendant or a legal person, personal service at the defendant's business premises on persons who are employed by the defendant. So it would be valid service. However, Mrs. Gatti needs to accept such service in order for it to be valid. We can move on to the question 3.
We do actually have a comment from Mr. Tischler, but I think it just refers to, he says, we should check the information about the competent court in Croatia. But all you want to say, Mr. Tischler, is I suppose that like if you have, if you need to know which is the competent court in Croatia, you need to double check now, because apparently there was a recent change in law, which means that the information right now on the EU Justice portal is not accurate.
Yeah,
Correct? Or do you have any further question on that topic?
I mean, I was just suggesting that. I was just suggesting that all information should be maybe checked. I mean, you're safe if you're, I can say, more sure that the information is accurate if the date of last update is a recent date. I mean, for some states, I think the e-justice hasn't been updated for some time, which does not mean that the information is not accurate. I was just checking. Okay. Question 3, suppose that Mr. Pasquale received the order and sent his opposition without specifying the reasons. So would this be an effective opposition against the European order for payment? So the question refers to legal remedy against the European order for payment. And the answer, for answering this question, we should check Article 16, which is the provision regulating opposition to the European order for payment. Specifically, paragraph 3 prescribes that defendant shall indicate in the statement of opposition that he contests the claim without having to specify the reasons for this. So it is not necessary to go into details as to why the statement of opposition was submitted. Let's say fourth variation of facts. Let's say that Mr. Pasquale.
Excuse me, Daniel, I'm jumping in again. Please excuse me. I don't want to interrupt you all the time, but Mr. Tischler, so Mr. Tischler, please, just if you like, if you have a microphone, talk to us. That's very interesting. Apparently, he had this problem already in practice that he.
I'm sorry, I do not see the chat because I have this.
Oh yeah, you cannot see the chat, so I will try to be more more attentive. But Mr. Tischler, please tell us if you like what happened. and how you solved the issue then.
Yeah, of course. I can tell you something about our story. Yeah, we filled in and brought in the formula for European order of payment at the Trgovački sud in Croatia, because we related to the information on the internet on the e-justice homepage, and it was wrong. But the Trgovački sud in Zagreb forwarded our claim to the Općinski sud in Rijeka, so it was a step more needed to get the court of competence, but resolved it in a nice way. But it's the problem that the information on the internet was wrong, not updated.
But I mean, this is a huge issue. This should be done soon, right?
Yeah,
I mean, they
was
cannot wait 2 years until they update.
Too, yeah, but
Yes, I agree. So
but they checked information today during the seminar, and it's still wrong.
yes, it is.
I mean, honestly, Daniela, maybe we should initiate somehow that they change it. This is just a joke, no? I mean, that's not how it's
Yeah,
supposed to
but-
work.
I agree. So member states should be much more quick with.
Maybe we can solve this problem as a side effect of our project and just like
Yeah.
write an email or
we can-
something, because
Yeah.
this is not how it's supposed to be. And so this is also interesting. So in Croatia, there is an ex officio sending of the case to the competent court also in these cases.
Well, I'm not
Obviously.
an expert, but I would say no. This is probably done in not so official way, because
Yeah, but I think I guess the Trgovački sud in Zagreb recognized the problem and solved it in really in a nice way. But yeah, but it's still the problem of the wrong information on the internet. So this should be solved for the future. But yeah, but in our case, it was only one step in addition. But yeah, it's now on the competent court, and we are waiting for the proceedings. So.
Well, thank you so much for
Fine.
sharing. That's really
Okay,
interesting.
yeah.
Thank you.
No problem.
yeah, thank you for your comment. I mean, we had the previous two seminars, which were held just for Croatian practitioners, and we discussed about this. So it was, we had our first seminar in December last year. So we were actually discussing about the fact that there were information on Injustice Portal which were not accurate. So yeah, I'm glad you shared this case, although I'm not glad Croatia was used as the example of not updating the information in a timely manner. Okay, so yes, so we can move on with the question 4. Let's say that Mr. Pasquale received the order and sent his opposition. However, he forgot to sign the Form F. Is this a valid opposition against the European order for payment? So Form F is the form in the annex which should be used by the defendant to oppose the European order for payment. And the issue of not signing the opposition is dealt with Article 16, paragraph 5, which says that the statement of opposition shall be signed by the defendant, or if it is applicable by the representative. And if it is submitted in an electronic form, because some member states accept the communication via emails, then e-signature can replace the regular signature. So in accordance with the rules which are in place concerning electronic signatures. So suppose that Mr. Pasquale sent the opposition in accordance with Article 16, which means that everything is in order, so he didn't forget to sign it this time. And what would be the effects of sending the opposition? So this was covered by Judge Manester. She explained that the effects of opposing the European order for payment are dealt with in Article 17 of the regulation, and which basically says that if the statement of opposition is lodged within the specified time period, then there are actually two scenarios. One is that the proceedings will continue in accordance with the rules of the European small claims procedure regulation, or the other scenario is that the proceedings will proceed, will continue in accordance with the rules of national procedure. Of course, when submitting the claim, the party can specify that it does not want to proceed with national procedure. The question 6, again, it's a variation dealing with opposition. So suppose that Mr. Pasquale received the European order for payment and did not oppose. The Spanish court declares the order enforceable using standard form G. And what does Mrs. Garriga have to do in order to enforce the order in Italy? So the answer to this question should be found in Article 21 of European Order for Payment Regulation, which says that in order to enforce a European order for payment in another member state, the applicant should provide standard forms E and standard form G. So standard form E is the form by which the court actually issues the European order for payment, and the standard form G is used for declaring it enforceable, declaring the enforceability of the European order for payment. And a copy of the European order for payment, of course, in addition to these two forms, should be submitted, and where necessary, also the translation of the European order for payment into the official language of the member state of court proceedings, actually in the member state where the enforcement is sought. Okay, so that would be the first case. The second one is more focused towards jurisdictions, since this is the topic we discussed today in more detail. So the second hypothetical case refers to Mrs. Sturm, who is a German national domiciled in Munich, and she decided to spend a week in Croatia in February 2019. During her stay, she arranged for an aesthetic procedure at a clinic Aphrodite owned by a company with the same name, with its seat in Zagreb. And she found out about the company through a paid advertisement in German language, which appeared as a search result on aesthetic surgery clinics in her web browser. It led, so the paid advertisement led to a company website, Aphrodite Skin Beauty, which had actually a German domain and used entirely German language. After the procedure of facelifting, she developed severe skin inflammation and irritation. And after returning back home, she needed to undergo several procedures to remedy her skin condition. She failed to pay, and the company sought legal advice on recovery of the amount due. So basically, the first question refers to which of the regulations can be used for recovering this debt. Can the company use any of the here mentioned regulations, European Order for Payment Regulation, Small Claims Procedure Regulation, and or regulation on uncontested claims? So the company, the answer would be that the company may use both regulation on European Order for Payment and regulation on European Small Claims Procedure. European Order for Payment regulation may be used if a case is a cross-border one and if it refers to a pecuniary claim, if it deals with a pecuniary claim. And for the purposes of the European Order for Payment regulation, a cross-border case is defined as the case in which at least one of the parties is domiciled or is habitually resident in a member state other than the member state of the court seized, which is defined by Article 3. And here both conditions are actually fulfilled. The case concerns the pecuniary claim, and since the parties are domiciled in different member states, then also the precondition of cross-border case would be fulfilled. Regulation on European small claims procedure, on which we will talk tomorrow in more detail, applies also in cross-border cases to civil and commercial matters. And the value of the claim should not exceed 5,000 euros. And for the purposes of this regulation, the definition of cross-border case is the same as in the European Order for Payment regulation. So they define the cross-border case in the same manner. And also we heard a lot about the notion of the civil and commercial matter. So this is what Professor Kunda indicated. It goes both for the European Order for Payment regulation and the regulation on European small claims procedure. So I will not go into details on these matters since they were discussed before. As for the third regulation, which is mentioned here in question 1, this is a third regulation, which was along with the European Order for Payment and European Small Claims Procedure enacted as an instrument which is supposed to be complementary to the Brussels 1 bis regulation, or more precisely to its predecessor, the Brussels 1 regulation, which dates back to 2001. And they serve as a supporting mechanisms to Brussels 1. And the main reason for adopting this regulation on uncontested claims was the problem that arose, which actually referred to the situation when the creditor has to obtain from a court an enforcement title in situations where debtor does not pay a claim and the claim is not disputed. So this regulation introduced abolition at exequatur for certain categories of judgments. And in order for a party to be able to rely on provisions of this regulation, there has to be a judgment rendered by the court. And here we are still in the phase of the proceedings in which proceedings were not instituted. So only the first two mentioned instruments of European private international law can be used. We can move on to the question 2, sorry. So if the Aphrodite decides to use the European Order Payment regulation for enforcing the claim, the court of which member state will have jurisdiction? So the answer to this question should be found in Regulation on European Order for Payment, the Article 6. So the Article 6, as Professor Kunda explains, refers to the Brussels 1 bis regulation for determining the international jurisdiction, with exception of consumer disputes. The Article 6 actually contains an exclusive jurisdiction rule for consumer disputes, which actually is more broad than the one contained in the Brussels 1 bis regulation. Since the Brussels 1 bis regulation rule, which deals with consumer disputes, requires that additional conditions have to be applied, have to be fulfilled in order for the section on consumer contracts to be applied. So the Article 17 from the Brussels 1 bis regulation to which I am referring requires, apart from the fact that the contract has to be entered by a natural person acting outside of his or her trade or profession, it either needs to be a contract for the sale of goods on installment credit terms or a contract for a loan repayable by installments or any other form of credit, which is made for financing sale of goods. Or the third option is that the trader either directs his activity to the member state of the consumer or pursues his professional activity in the member state where the consumer is domiciled. If neither one of these conditions is fulfilled, then the natural person, the consumer, cannot rely actually on the section on consumer contracts in Brussels 1 bis regulation. And on the other hand, European Order for Payment regulation does not contain these additional prerequisites. So it is enough that a natural person enters into a contract with a trader. And in this case, the exclusive jurisdiction lies with the court of the member state where the consumer's domicile is located, but only if the defendant is the one being sued. So the exclusive jurisdiction rule only deals with the situation in which the consumer is the one being sued, as is the case in this hypothetical example. So if the consumer is the one being sued, then the European Order for Payment application needs to be submitted before the court of the consumer's domicile. And since it was specified in this case that the trader had this website, there is an additional case that needs to be mentioned, which is the case Palmer and Alpenhof. I'm sure some of you are familiar with the case. It is a judgment by the Court of Justice of the European Union in which the court explained when can a website be considered to direct activities to the member state of the consumer's domicile. So which conditions need to be fulfilled so that national courts can establish that the trader actually wanted to direct his activity into the member state where the consumer's domicile is located. And the court came up with a list of factors which are not exhaustive. And so additional factors can be also taken into consideration. For instance, the court mentioned the fact that the website uses the national domain, which is different than the national domain used in the member state where the trader is seated. It also mentions the fact that website contains some sort of referral to itinerary on how to get from one member state to the traders' offices or traders' location. Furthermore, it mentions international nature of the activity, use of currency and language, which are not usually used in the member state where the trader is domiciled, and so on. So when talking about directing activities over the internet, then this also needs to be taken into consideration, but only if Brussels 1 bis rules are applicable. So here, or when we talk about situation in which Aphrodite decides to use European Order for Payment Regulation for enforcing the claim against the consumer, then this additional requirement of directing of activities doesn't have to be fulfilled, since we are within the realms of Article 6 of the European Order for Payment Regulation. Okay, so the next question refers to international jurisdiction if the company decides to use the European small claims procedure for enforcing the claim. We haven't discussed international jurisdiction for the purposes of the European small claims procedure. However, the rules that were presented in the previous presentation apply. So if we take a look at the European Small Claims Procedure Regulation, actually there is no reference to the application of rules of jurisdiction contained in the Brussels 1 bis. The regulation on European Small Claims Procedure only refers to Articles 62 and 63 of the Brussels 1 bis regulation, which deal with the issue how to determine the domicile. But still, since this is a cross-border case, even if the party decides to use the European Small Claims Procedure, the rules on international jurisdiction should be applied from the Brussels 1 bis regulation. So since the European Small Claims Procedure does not contain a jurisdictional rule which would correspond to the one contained in Article 6 of the European Order for Payment, then for consumer disputes, we directly apply the section on consumer disputes in the Brussels 1 bis regulation, which means Article 17 and 18. And Article 18 prescribes that if the consumer is the one being sued, then the trader has to do so before the courts of the member state where the consumer has his or her domicile. So basically, we would come to the same result in the end. The fourth question refers to prorogation of jurisdiction. So do the procedures in European Order for Payment and European Small Claims Procedure Regulation, do they allow that Aphrodite and Mrs. Sturm agree on the jurisdiction of Croatian courts? So under the European Order for Payment Regulation, as we already established, Article 6 as the exclusive jurisdiction rule should apply, which means that the possibility of agreeing on a competent court and even tacitly prorogating a court are excluded. So this would not be an option. It would be different if the consumer was the one instituting the proceedings against the company. Then this would be an option. And under the European Small Claims Procedure Regulation, this would be allowed since Article 25 of the Brussels 1 bis regulation would be applicable. Basically, Article 25 of the Brussels 1 bis regulation allows the parties to agree on a competent court for a specific legal relationship. And Article 25, the most important part of the provision is probably the one on formal validity of agreement on jurisdiction. So the agreement needs to fulfill one of the conditions from points A to C with regards to the form in order for the prorogation to be valid. Question 5.
Can I ask you something
Yeah,
there?
yeah.
Because the prorogatio fori is generally allowed. However, since the one party is a consumer, that could be problematic, right? Because you cannot, according to Article 25, you cannot break the rules of consumer protection there, right?
Yes, exactly. So when we are talking about consumer contracts, then apart from Article 25 and the rule on formal validity, there has to be an additional prerequisite fulfilled. And
Which is that there has already been a dispute, right?
yes, and this is prescribed by Article 19 of the Brussels 1 bis regulation, which says that that either the dispute, actually the prorogation, has to follow the dispute. So the dispute needs to arise before the parties actually agreed on a competent court. And probably the ratio behind this is to protect the consumer, in the sense that consumer will probably think more about the consequences of agreeing to a jurisdictional clause once the dispute has already arisen, uh, in comparison to the situation in which there is no dispute yet, and he or she will just sign anything provided by the trader. The other condition is that the consumer actually is provided with an additional option. So basically, Brussels 1 bis gives two options to the consumer when he's the plaintiff. He or she can choose whether to institute the proceedings before court of his or her own domicile in his home state, or if he or she wants to sue before the courts of the member state where the trader is domiciled. So if parties conclude a prorogation agreement, which is in accordance with paragraph 2 of Article 19, then that prorogation agreement needs to give to the consumer an additional third forum as an option. And this is only at the disposal to the consumer. So the stronger party, the trader, cannot benefit from this third jurisdictional option. And then there is the final condition. I mean, only one of these three has to be fulfilled in order for the prorogation agreement to be valid. The last one deals with the situation in which they both have the same domicile or habitual residence, and they decided to agree on a competence of that court.
Thank you for clarifying, and sorry for asking stupid questions.
No, thank you. Thank you for reminding me. I skipped that part. Okay, so I think we should proceed with, yes, question 5. So here is the variation of the facts in the sense that the circumstances changed. Aphrodite does not have a website and does not target German consumers. And Mrs. Sturm found out about the clinic when she saw a billboard during her stay in Croatia. Does that affect the jurisdiction of the courts? So under the European Order for Payment regulation, the answer would be no, because again, the directing of activities is not required, as neither of A, B, or C has to be fulfilled for application of Article 6 in European Order for Payment regulation. And under European Small Claims Procedure regulation, the answer would be different. As I mentioned previously, if this regulation is the applicable instrument for recovering cross-border debt, then rules of Brussels 1 bis directly apply, which means that if these additional conditions for a consumer contract to actually be covered by the consumer contract section in the Brussels 1 bis are not fulfilled, then other provisions of the Brussels 1 apply. And so we should establish whether provision of Article 7 on special jurisdiction for contracts, which is regulated by paragraph 1, is applicable. So Professor Kunda mentioned this provision. Article 7, paragraph 1 contains general rule for all contracts, and then a specific rule for contracts for the sale of goods and provision of services. So if a contract is the one for sale of goods or provision of services, then points referring to those contracts should be applied and should be applicable. And if the contract at issue is neither sale of goods nor provision of services, then the general rule applies. Here, we can qualify this contract, characterize it as a provision of services contract. So there is a case law on qualification of provision of services contract. It was done in a case Falco Privatstiftung, in which the Court of Justice of the European Union clarified that the concept of service implies at least that one party who provides the service carries out a particular activity in return for remuneration. This was the case in which the license contract was at issue. So one party only allowed the other to use the copyrighted material and got remuneration for that. So that contract was not qualified as the provision of services contract, since there was no activity which was actually done. So, but here in this hypothetical case, the contract issue can be characterized as a provision of services contract, which means that the court where the services were provided is the competent one, and this would be the Croatian court. When rules on special jurisdiction from the Brussels 1 bis apply, the general jurisdiction rule also applies, as the court has explained in numerous judgments. These two are actually complementary. So the plaintiff is the one who chooses whether to institute the proceedings in accordance with the general jurisdiction rule or the special jurisdiction rule. So apart from that, apart from the fact that the Croatian court would be competent based on Article 7, paragraph 1, also the German court would be the competent one, since the defendant has her domicile in Germany. The sixth question: if Aphrodite instituted the proceedings under regulation on European order for payment before the Croatian court, and Mrs. Sturm wants to object to the jurisdiction, how can she do so? So, European order for payment regulation does not contain a specific provision based on which the defendant could object to lack of jurisdiction. However, Article 16 is applicable, so the defendant can oppose European order for payment without specifying the reasons for opposition. And this would be enough actually for contesting the European order for payment. And in relation to this, maybe we can also mention the judgment Thomas Cook. So in this case, the Court of Justice of the European Union actually explained whether jurisdiction may be challenged not within the realms of Article 16, but within the ambit of Article 20 of the European Order for Payment Regulation, which deals with review in exceptional cases. So in this Thomas Cook case, the travel agency, Thomas Cook, entered into a contract with Turner Hotel for the provision of hotel accommodation. And the proceedings were instituted before the Vienna Commercial Court for issuing European order for payment against Thomas Cook, and Turner Hotel claimed that Austrian courts have jurisdiction since the services were provided in Austria, so they were relying on Article 7 of the Brussels 1 bis regulation. And the European order for payment was served on Thomas Cook, and it lodged a statement of opposition after the expiry of the time limit of 30 days. So Article 16 was no longer an option. And Thomas Cook claimed that the jurisdiction lies with the Belgian court and applied for the review of the European order for payment. And the Court of Justice in this case actually established that under these circumstances, actually 2 levels of assessment need to be done. And the first assessment is whether the European order for payment was clearly wrongly issued, having regard to requirements laid down in European order for payment regulation. And here the Court of Justice explained that this is not the case, since the national court should examine the application, including the question of jurisdiction and the description of evidence on the basis of what was submitted in the application form. And if the defendant wishes to raise objection to the jurisdiction of the court, he needs to do so by contesting the claim in accordance with Article 16. And the second level of the assessment is actually whether the European order for payment is clearly wrongly issued due to other exceptional circumstances. And the Court of Justice explained that these other exceptional circumstances could include a situation in which European order for payment was based on false information, which was provided by the plaintiff in the form. But this was not the case in Thomas Cook, Belgium, because once Thomas Cook received the application form, he became aware of the circumstances and he became aware of the ground of jurisdiction that was being specified. So he or the company had the opportunity of opposing the European order for payment. Okay, so the 7th question. Suppose that Mrs. Sturm wants to apply for a European order for payment against Mr. Horvat, who is a Croatian domiciled doctor who performed the procedure and recovered the costs of procedures she needed to undergo to remedy her skin condition. Can European order for payment regulation be used for recovering this claim? We heard about the ambit of the application of the European order for payment at the beginning of today's seminar. So according to Article 2 of the European Order for Payment Regulation, claims which arise from non-contractual liability are outside of the scope of the European Order for Payment Regulation, unless they have been the subject of an agreement between the parties, or if they relate to liquidated debts arising from joint ownership. So in a very limited number of cases, non-contractual liability can be covered by European Order for Payment Regulation. And the Court of Justice of the European Union had opportunity to characterize non-contractual liability by actually saying that the national court first has to check whether the legal relationship at issue is a contractual one. And the contractual relationship needs to meet the threshold that at least one party needs to freely assume an obligation towards the other. If this condition is not met, then we should check whether a case is a non-contractual one. And actually, non-contractual cases were defined as the proceedings which were aimed at establishing the defendant's responsibility, which is not connected to the contract. And this was in the Kaufeli's case. So maybe we can briefly comment on what would happen under European small claims procedure. So would European small claims procedure be applicable instrument if Mrs. Sturm wants to recover debt against Mr. Horvat? So in case of European small claims procedure, the ambit of application is differently set. So Article 2, which deals with the scope of application, mentions only violations of privacy and rights relating to personality, including defamation. So non-contractual liability is not excluded from the scope of this regulation as a principle, but only one category of such disputes, and this would be the ones instituted since some kind of violation of personality rights arise. And in conclusion, this would mean that regulation on European small claims procedure could be applied for recovering this claim against the doctor with which Mrs. Sturm had a non-contractual liability. Okay. So we have one final claim, one final case. If Philip and Eva agree, if you don't think everyone is too tired.
No, we very much enjoy you going through these cases. It's actually very entertaining. So please, if you like, please go on.
Okay, so the final hypothetical case: Mr. Kovac, a Slovenian national domiciled in Maribor, accessed the website of the company Lucky Dice, offering online gambling services, and the company was seated in Malta in October 2019. The company directs its activity to Slovenia, among some other member states. Mr. Kovac opened a user account and played online poker, and in January 2012, the company blocked user accounts of Mr. Kovac since he opened 2 user accounts, which is prohibited by the company's terms and conditions, to which Mr. Kovac agreed during registration. Lucky Dice withheld the amount of 50,000 euro, which Mr. Kovac won, and decided to institute the proceedings for recovering the amount of 2,000 euro, which was already paid to Mr. Kovac. On 11th March 2012, Lucky Dice decided to apply for the European order for payment. So again, the first question refers to jurisdiction. So courts of which member state have jurisdiction for issuing European order for payment. In addition to everything previously said about jurisdiction for consumer contracts, here I'd like to mention one of the recent cases. It's a case Personal Exchange International, and this hypothetical description is actually based on this case. In it, the Court of Justice of the European Union had a chance to establish whether a person who plays online poker must be considered a consumer. So even though the person perhaps gets a lot of money, so earns substantial sums of money by playing online poker and doing that for 9 hours per day. And the Court of Justice actually concluded that that person has to be considered as a consumer as long as he or she does not register an activity and starts offering this to third parties. So even though we can say that these are the professional poker players, they are still considered consumers for the purpose of the Brussels 1 bis regulation, which is actually, well, in all of the consumer cases, Court of Justice always starts its reasoning by explaining that that actually characterization of a contract as a consumer has to be limited to only to certain cases. So the interpretation should not be extensive, but then in the end, everyone is a consumer, even persons who generate a great amount of money playing online poker. So to answer the first question, Article 6 of the European Order for Payment would be applicable. So the Mr. Kovac, the consumer, needs to be sued before courts of his member state, so Slovenian court. Okay, the second question, suppose that Lucky Dice applied for European order for payment before the court on Malta. The court on Malta issues a European order for payment on 8 April 2020. Does a statement of opposition in which the jurisdiction of the court on Malta is not contested constitute the tacit prorogation of jurisdiction? So tacit prorogation of jurisdiction is regulated by Article 26 of the Brussels 1 bis regulation, and the provision basically says that even if jurisdiction does not is not based on any of the existing jurisdictional criteria in the Brussels 1 bis regulation, if the defendant enters an appearance and does not contest the jurisdiction, but instead starts to discuss on the merits of the case, that court can declare itself competent based on Article 26 of the Brussels 1 bis regulation. And actually the answer to this question was provided by the Court of Justice of the European Union in the case Goldbet and Sperindeo. So the case concerned Mr. Sperindeo, who actually entered into a contract with Goldbet, Austrian company. It was a company which organizes sports betting services, and he was supposed to set and operate such betting services in Italy. He was required to collect bets and send the sums agreed to Goldbet. And since Mr. Sperindeo did not act in accordance with the contract, he failed to fulfill his contractual obligations. The Goldbet company applied to the Vienna District Court for commercial matters and asked from the court to issue European order for payment against Mr. Sperindeo. And Mr. Sperindeo, acting through his lawyer, he lodged a statement of opposition to the European order for payment with the prescribed time limit of 30 days. But he based his opposition on the fact that the claim was unfounded. So he did not mention the issue of jurisdiction. And the questions were referred to the Court of Justice of the European Union and the National Court in Innsbruck. sought clarification from the Court of Justice of the European Union as to whether the tacit prorogation occurs when the defendant does not contest the jurisdiction. And the answer was basically no. So if a statement of opposition to European order for payment does not contain any challenge to jurisdiction, this still does not constitute submission to jurisdiction in the sense of Article 26 of the Brussels 1-bis regulation.
Also, I mean, the court has to make sure that the defendant, if he or she is a consumer, knows about his or her right to raise the problem of jurisdiction. And so this is actually interesting because like now we have a different regime for consumer jurisdiction, but still I would say that this has to apply here, right? So probably before, even if there is, yeah.
So,
I mean, even more in this case, because if there's an ordinary procedure, then we don't have a European order of payment anymore anyways. Still, I think like even more, it has to apply here that there cannot be, maybe in a different case that would be different, but especially in a consumer case, I would see that very problematic, right? Because the court has to raise or give the consumer the opportunity to say, excuse me, this is, or there's no international jurisdiction.
yes, definitely that would be a valid comment if we are talking about European small claims procedure. But if we are in,
Yeah, but then we don't have Article 6, paragraph 2,
yes,
right? So I mean, this is weird.
It's weird, yeah, because the consumers get a different treatment in same factual circumstances, and it all depends on which of these instruments the plaintiff decides to apply. Because under European Order for Payment regulation, there would be no place to apply Article 26 if the consumer is the defendant. And furthermore, it is interesting to think about what happens if the court does not warn the consumer and other weaker parties on the fact that they can object to jurisdiction and the consequences of not objecting. Because if we look at the recognition and enforcement provisions in Brussels 1, there is no actually ground for refusing recognition and enforcement if the consumer and other weaker parties were not properly warned in the sense of Article 26. So
Hold on, but this is Article 45.
yes, point E, but it
Yeah,
also refers to section on consumer contracts. So if we use the literal interpretation, the linguistic interpretation, this might not be a ground for refusing the judgment. However, if we think about the purpose, then one should come to the conclusion that still this has to be a reason for refusing recognition and enforcement. I'm not sure.
I would honestly, I mean, this is, we should probably not delve into
Yeah.
super depth here.
Yeah.
I mean, anyways, you can raise this since there is no progression for according to Article 26. You
Yeah.
can still raise the problem according to national law. But if this does not happen and you actually have a judgment, I would still think that the jurisdiction was not in according with those
Yeah, that would be my
provisions, and
answer
that
as well.
this constitutes, so this would be my guess, but I would have to look into that deeper. But I feel like this is probably a ground for refusal.
Yeah, I agree.
But if you know better, Daniela, please tell me. I mean,
I would also opt for the theological interpretation of
Uh-huh.
provisions, not only linguistic ones. But I
Okay.
haven't found the exact answer, and I don't think the court provided an interpretation on this. But
Sorry, I'm being quiet now.
Really specific issue. So, okay. Okay, so we can move on with the question 4. So suppose that Lucky Dice submits the application for European order for payment on 11th March 2020 to the Slovenian court, and the Slovenian court requests from Lucky Dice to submit additional documentation relating to the contract, particularly its terms and conditions, with the aim of exercising control over contractual terms in accordance with provisions of the directive on unfair terms in consumer contracts. And how should the question of the supply of these additional documents be solved for the purpose of ex officio control of contractual terms? So basically this question is here because we wanted to draw the attention to Bondora judgment. It is a judgment from 2018, in which Bondora, a company whose registered office was in Estonia, concluded a loan agreement with consumers who were both domiciled in Spain. And Bondora lodged an application for European order for payment with the Spanish court. And the Spanish court asked Bondora to provide additional documentation apart from the claim form, from claim form A, in order to be able to assess whether the contract contains terms which might be deemed unfair based on the national legislation through which the directive of unfair terms was transposed. And the Court of Justice established that the companies should provide such additional documentation if asked by the court, since directive on unfair contract terms considers the consumer as a weaker party and requires that member states make sure that unfair contract terms used in a contract concluded with the consumer are not binding, are actually null and void. And in order to do so, the court has to be able to require additional documentation in order to be able to make such an assessment. Question, I think we are at question 5. Suppose that Lucky Dice submits the application for European order for payment on 11th March 2020 to the Slovenian court, and the Slovenian court finds that the Lucky Dice did not fill in the part 7 of the application form from Annex A correctly. Should the Slovenian court reject the application? So part 7 of the application form deals with interest, I think, or calculation of the principal. We should check that in any case. However, the answer is provided by Article 7 of the European Order for Payment Regulation, which says that the court should first, unless the claims are clearly unfounded or inadmissible, the court should give the claimant the opportunity to complete or rectify the application. And for this purpose, there is a standard form B annexed to the regulation. And if the court requests from the claimant to complete or rectify the application, it also decides on the time limit in which the claimant should do so. Article 6, question 6, I'm sorry. We talked so much about Article 6 and consumer contracts. So. Okay, so suppose that on 8 April 2020, the court issued the European order for payment, and on 20th April, it was served on Mr. Kovac by depositing it in mailbox of Mr. Kovac's apartment. And he was hospitalized due to contracting COVID-19 and was released from the hospital on June 20th. can Mr. Kovac oppose European order for payment? So the answer should be given by Article 20. So it's the provision on review in exceptional cases. So after the time limit of 30 days within which the defendant can oppose the European order for payment, the defendant can ask for the review of the European order for payment in exceptional cases. And the situations in which this can be done are defined by Article 20. And the provision says that, first of all, the order for payments has to be served by one of the methods provided in Article 14. And this is the article which deals with the service when no proof of receipt of the defendant exists. And in addition to that, service was not effected in sufficient time to enable the defendant to arrange for his defense. So if these two conditions are met, then the defendant can ask for review in exceptional cases. And he has to act promptly. So as soon as circumstances allow him to ask for this revision, he has to act promptly as soon as possible. The second situation in which the review can be asked is when the defendant was prevented from objecting to the claim by reason of force majeure or extraordinary circumstances and without any fault on his part. And then paragraph 2 talks about an additional situation, which was actually explained in the judgment that I mentioned previously, Thomas Cook, when the order for payment was clearly wrongly issued, having regard to the requirements which are laid down in this regulation. And the European legislator issued guidelines on European order for payment. And if we look at these guidelines, I think in one of the footnotes, it says that whenever the defendant was, I think, on holiday or in the hospital, this falls under, let's say, allowed reasons for review in exceptional circumstances. Okay, and we come to not the last question, but the question 7. So suppose that on 8 April 2020, the court issued the European order for payment, and it was served on Mr. Kovac's representative on 20th April, and the representative did not oppose to the European order for payment. On June 15, Mr. Kovac found out about the European order for payment, and can he oppose the European order for payment? So the time limit for opposing the European order for payment is in this case passed. And similar circumstances occurred in case Novontech Zala, in which the Court of Justice of the European Union explained that if a representative wrongly calculates the deadline of 30 days, the time limit of 30 days, this cannot be a ground for asking the review in exceptional circumstances in accordance with Article 20 of the regulation on European order for payment. So a failure to observe the time limit for lodging the statement of opposition due to negligence of the representative of the defendant does not justify a review of that order based on Article 20 of the regulation. And finally, suppose that Lucky Dice applied for European order for payment before the court on Malta. The court on Malta issued the European order for payment on 8 April 2020, and it declared the European order for payment enforceable. Lucky Dice institutes the proceedings for enforcement in Slovenia. Can Mr. Kovac oppose the enforcement of the order before the Slovenian court due to lack of jurisdiction? So once the enforcement proceedings have been commenced, this is not one of the prescribed grounds on which enforcement can be rejected in accordance with Article 22 of the regulation. So basically, regulation only cites the reason if the European order for payment is irreconcilable with an earlier decision or order. And this is not the case. So enforcement can only be refused if the earlier decision or order exists and it holds the same cause of action and same parties, or it fulfills the conditions necessary for being recognized in another member state, or there is also a situation in which the defendant already paid the claimant the amount. However, the issue that is described in question 8 cannot be a ground for refusing the enforcement of the European order for payment. But for this purpose, there is, yes, this is due to the principle of mutual trust, which exists between member states of the European Union and which actually forms one of the cornerstones of these regulations which contain procedural rules. So one court of one member state cannot go into assessment as to whether the court of another member state wrongly decided on jurisdiction, save for certain exceptions which we already mentioned, and these are the weaker party contracts. But as a principle, this cannot be done. Okay, so I would like to end here, and if anyone wants to comment something or maybe ask a question, I'll be more than glad to discuss it.
Well, thank you so much, Daniela. You put together such a great case, or so great cases, and you worked in so much case law actually that was very interesting and entertaining. Also, you fulfilled every student's dream here, and you were not a mean professor asking students to answer questions. Instead, you just solved the cases yourself. That was very nice of you. Thank you for your presentation. We enjoyed it very much. Ladies and gentlemen, do you have any questions? It's late already, we understand that. If this is not the case, I mean, if you come up with any questions, there is another session tomorrow starting at 3 p.m. And you will, of course, have the opportunity to ask questions tomorrow if you come up with anything that remains open during the night or tomorrow in the morning, and you're like, how is that supposed to be done? And Daniela is certainly glad to answer your questions tomorrow as well. If there are no more questions, let me thank you for your attendance. Thank you again, Daniela. And I guess we see some of you tomorrow again at 3 p.m. Thank you and have a good evening.
Thank you for sticking so long, and see you tomorrow, hopefully. Okay.
And do you have still 2 minutes, Daniela?
Yes, okay. I do.
Perfect.
I can
Let's just wait until people.
Yeah, sure. I will remain connected.